it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. Cause Sweet Peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when Sweet Peas in the building, we be learning with pride. My eyes on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Like to with the facts, pretty brown girl with the sass. Moreldia and Fala keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet Peas got the fight, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. Sweet Peas nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial. Take it to trial. Take it.
Y'all thought I was gonna hit y'all 2 times with that? No. Let's start, court. All rise, please. Hear ye, hear ye. Take it to trial, and the Sweet Pea gang has entered the courtroom. This is Fani Willis, Fani, Nathan Wade, motions to disqualify hearing in the Georgia Trump case.
Is still not with us in person. However, there's a proposal to potentially move on to other witnesses. Why don't we start with the state? Ms. Cross.
Thank you, Your Honor. Yes, in order to be efficient with the court's time, we have a witness here and prepared to take out of order, and it sounds as though there's no objection from the defense, so we can do that at court convenience.
We don't have any problem keeping him out of order, but it's our understanding Instructor Barnes is here to establish that he was the first choice of Ms. Willis, and she testified to that, so I don't think she's cumulative. I don't know why we need to call him to establish the fact it's already been established. We're not refuting that fact. Is there a feature on that fact?
Ms. Cross, I think did she say it was her first choice? Did she not say who was her first choice?
I think that's, I don't believe that the governor's name was mentioned. I think there are some facts and circumstances surrounding the search for someone to take over the lead of this investigation at that time. Now, prosecution is something that, given the allegations in the case, is certainly relevant.
All right. It doesn't sound like it would be all that long a witness.
I don't think
anyhow. All right. So in that case, we can transition over. And Ms. Cross, I'd like to call your witness.
Thank you. The state would call Governor Roy Barnes.
And Judge, just so I'm clear, so you had told us not to ask questions about qualifications. So we did not ask any of our witnesses about qualifications. So the state's now going to bring in evidence of that. We would just ask I'll be able to go into that.
Sounds to me, well, Ms. Cross.
If you want to ask Governor Barnes about his qualifications, that's certainly something you have knowledge of. I don't know what his basis of knowledge for anyone else's qualifications might be, but I also don't think that opens the door to anything other than my understanding of what the testimony is.
As I hear it, the issue of qualifications versus who was her first choice is going to be relevant to her intent, maybe, and perhaps that issue of the case in whole. I don't think that necessarily opens the door. We'll see how it goes.
I believe he's being brought up, Your Honor.
All right. I do.
Roy Eugene Barnes, Royeugene, Barnes, Barnes.
Say, good morning, Mr.
Morning.
Barnes. Can you tell the court a little bit about your background as it relates to your service in public service?
I was first elected to the state senate in 1974 from Cobb County, and I served 16 years there. And then in 1990, I ran for governor and was defeated. And 2 years later, I went back to the House of Representatives. I was elected to the House of Representatives, served 6 years until I was elected governor in 1998, and I served in that position until January of 2003.
And after serving in the position of governor, can you tell the court a little bit about what you transitioned into after your public service?
I did exactly what I was doing before I was elected. I went back to practicing law in Marietta, Georgia, with my daughter, who's now judge of the state court, and my son-in-law. And now we have, I think, 6 or 7 lawyers. Charlie Bailey back there was one of them at one time.
Okay. And Governor Barnes, would you consider yourself to be a trial lawyer?
Yes. That's
Okay.
We don't write contracts or we don't write wills. All we do is try cases.
And I want to direct your attention back to 2021, where you approached by the district attorney of Fulton County, Fani Willis, about being a special prosecutor.
I was. I don't recall the exact date, but I know it was sometime in 2021. And she asked me to come down, and I met with her and Nathan Wade, and there were several other in the meeting. She asked me, said they were beginning this investigation, and she asked me if I'd be interested in being special prosecutor, to which I replied that I had mouths to feed at a law office, and that I would not do that. And also, I just had a bad, well, I won't say bad because it happens from time to time, but I just had FBI to report a fella, militia trainer, to me that said they were concerned that he was making threats against me. And because I thought it was because of the flag, but I asked him and he said, no, it was because I was too close to the Jews, quote unquote. And I told DA Willis I'd lived with bodyguards for 4 years and I didn't like it. And I wasn't going to live with bodyguards for the rest of my life.
Ultimately, you turned down.
Yes. Yeah, I told her. I said, I'm not interested.
Nothing further from the state.
Smash.
Morning, Governor Barnes. How are
Morning.
you?
Just fine. How are you?
Good to see you.
Good to see you.
You said it was sometime in 2021. Do you remember?
I think it
early?
was. I don't remember the dates. They all go. I could look it up on my calendar at the office, but I don't have that.
Well, I want to ask you about some statements that Ms. Willis made March 28th, 2021. She was talking about assembling a team for this case. Are you familiar with her work assembling a team for this case?
Well, I assume that's what she was talking to me about. But besides that, I don't know.
And I know you had said you had a meeting with some folks and Mr. Wade was at that meeting.
Correct.
Okay. So he was with the district attorney interviewing you about taking this case.
Well, of course, I know Nathan very well, as you do.
Yes.
And I exchanged pleasantries with him, but the conversation was with Ms. Willis.
Okay, with Ms. Willis. Were you aware at the time that her team consisted of Brian Watkins, Megan Vargas, Sonia Allen, Shannon Trotty, Sal Chan, and John Floyd? She had reported that was her team on this case.
I know John Floyd was involved, and she probably told me the others, but listen, I barely remember what case I tried last year, much less every word that was said in the conversation.
I understand, fair enough. But she said she was looking to hire more lawyers and investigators to work on this case.
She told me, it was to me, she said, would you be interested in being special prosecutor in this case? And I gave the reply that I've already known. I mean, about hiring other lawyers or whatever, I don't know. All I can testify to is what she told me.
Did she tell you at all why she wanted to hire special counsel and not use someone who is an ADA, not have an actual employee?
No, she did not. I mean, we did not discuss that. And, but I would assume it was because in a case as big as this, that you'd have to have a decision help. I know John Floyd has been in some cases over the years out in Cobb County, for example, and others.
Would you agree that an employee of her office, someone who was paid a state salary or a county salary as an ADA, could handle a case like this?
I couldn't tell you that unless I knew the person, knew their experience, and really had been with them in a courtroom.
All right.
Has an opinion on that.
Thank you.
Yes, ma'am.
Say no.
Hello, Mr. Sadow.
It's been a while.
It has been a while.
I hope you're well.
I'm doing fine, just getting older, but that beats all.
That's true, but that applies to all of us, I believe.
Yes.
I think you indicated that if you had your calendar, you'd be able to pinpoint a date for
I
us.
would.
Is there a way for you, for example, at a break before you actually leave, to contact your folks to see if you can get a date?
I guess I could. I don't know how far back we archived those, but I assume I could.
Would you be willing to give that a shot for us?
I mean, I'll do whatever the court instructs.
So if I ask the court and the court says, go ahead and you could do it, that's all right?
I'll do whatever the court instructs.
I hear you.
And you should too.
I try to live by those words. I'm not always successful, but I try. If I pinpoint a date, for example, I think the record is clear that Mr. Wade was hired for the position on November 1 of 2021. Does that help you at all?
No, it does not.
Then let's go to the meeting. It sounds like it was just one meeting.
Yes.
And could you tell us where that meeting took place, if you
It was in
remember?
the conference room adjacent to the district attorney's office.
So was it in this, or the adjoining building?
It was in the Lewis Slade building.
And District Attorney Willis was there, obviously, right?
Yes. Yeah.
And Mr. Wade was there?
The best I recall, now I could be mistaken about that. It's like anything that far away, but that's my recollection.
Do you have a recollection of anyone else being present?
Yeah, there was some other folks, but I don't remember.
Do you remember, were you introduced to Mr. Wade by anything other than you already knew him? Was he given
No,
a title
I
or
wouldn't have
anything?
known.
So at least as you're there, if I heard you correctly, Miss Willis did all the talking, Mr. Wade did not.
I mean, we exchanged pleasantries, but as far as the basis of the conversation, the reason I was there, Ms. Willis did the talk.
And would you be able to give us an estimate of how long this meeting lasted? Just
Probably-
rough.
Probably an hour.
And during the meeting, you made it clear, but it was the thanks for the offer, but no thank you.
Oh, yes, I did. As I said, I started off as a prosecutor, and for about 10 or 15 years, I did nothing but criminal. And then, but I've tried to move away from it and do primarily civil now. Mr. Gillen and I have done some white collar cases over in federal court. I've got one over there right now, but it's generally business related, where I have a client that's got a kid or him getting indicted. And the case I have over there now is an alleged fraud case.
Fair to say that based on your career and the work that you've done, you've handled high profile cases, correct?
I have. I've handled some pretty good cases. I sued Syria one time for beheading a client of mine, recovered $82 million. I guess that's the best high profile, but that was in D.C. I tried that up in D.C.
And what would be considered complex cases, you've handled those as well, correct?
Yes, I mean we regularly do mass torts, class actions, business torts, breach of contract, and most of those are high complex or complex, requiring many experts. We also do malpractice. I did malpractice defense for about 25 years, but since I've returned from the governor's office, I try not to represent an insurance company anymore. And I just tried a malpractice case before Judge Edlin in November. And those are complex cases because of the type of, medical knowledge and that you have to have, and also because of the many experts that you have.
Thank you. Did Miss Willis, and this is the last question, did Miss Willis tell you why she had sought you, why you had been her choice?
No, I hadn't, but I get consulted fairly often on major cases.
Would you believe, based on circumstances in which you were given the offer, that it had to do with the fact that you had handled complex and high profile cases in the past?
It could have been. I know her very well. I tried a case against her. She worked for the JQC, and I represented Judge Robert Crawford, Mac Crawford, and she prosecuted him, and I defended him. She beat me at the trial. I turned it around at the Supreme Court.
So you had some experience.
Oh, I had plenty of experience with it. She's a very qualified young. Well, everybody's young to me, but she's a very qualified young woman.
After that one occasion, did you have any other contact with her in reference to the position itself or who she might be considering?
I had some conversations with her or Jeff DeSantis or some of those, but not really an in-depth, about who she should hire or anything like that.
Did the name Nathan Wade come up in those conversations
No.
with her? No, right?
No.
Um,
Nathan was there, I thought. Now, I could be mistaken, but I thought Nathan was there when
for the
I think
conference.
Nathan was, I'm not positive Nathan was there when I met with him.
Right. And my question was probably poorly worded, but what I was asking is after the conference and whatever consulting you might have done.
Yes.
Did Ms. Willis or Mr. DeSantis bring up the name Nathan Wade as a special prosecutor?
I don't think so. I don't recall one. I mean, Nathan is a good organizer. Nathan can organize stuff. I've watched him over the years. So I wasn't surprised that he was acting as a special prosecutor.
And Mr. DeSantis, for the record, who was that? Jeff DeSantis?
Jeff DeSantis.
Do you know who he is?
Oh, yes.
Could you tell us who he is for the record?
Jeff works in the DA's office. I knew him when he worked for Thurber Baker.
Know what his role in the DA's office is?
I have no earthly idea.
Is he in media? Does that sound familiar?
He has done media in the past. Jeff has generally been, I like Jeff, and I'm very close to him, but he's generally been on the other side of my campaign.
All right, so we're talking the best of your recollection, conference, we don't have the date, I'm asking if you could possibly get it, but the conference you have, Mr. Wade could have been there,
Yes, I'm almost sure he was.
and Ms. Willis, obviously, and Mr. DeSantis was there.
I think Mr. DeSantis was too.
And as far as whether there was anyone else there, you
I
don't have a
don't.
present recollection?
No.
Okay, thank you, sir.
Next time I'll take a picture, so I'll have an exact,
And next time, hopefully, you won't have to be here.
well, hopefully not.
Thank you, sir.
All
All
right,
right, Mr. Stockton,
No questions, Judge.
thank you.
Mr. Durham,
No questions, Your Honor.
Mr. McDougall,
No questions for the governor, Your Honor.
Mr. Rice,
No questions, Judge.
Mr. Gillen.
I've been waiting for this.
I couldn't give up the chance getting up here, Governor. Good to see you again.
Good to see you,
We've
Craig.
done some work in the past together, haven't we?
I consider you to be one of my best friends and a crackerjack lawyer.
Well, I will say to you on the record that I can understand why they came to see you because you're the finest lawyer that I've ever worked with.
Thank you. I need to put you in the next day.
Yeah, there you go. We'll get that. But one or two more questions.
Okay.
You and I working together when it's appropriate. We've had no qualms about filing motions to disqualify the DA, have we?
No.
Matter of fact, you and I successfully disqualified the DA out in Cobb County in the Brown case, didn't we?
We did.
So whatever needs to be done should be
You
done.
represent your client.
You got that. Thank you so much.
Mr. Coturo, are you still with us by Zoom?
I am, Your Honor.
All right, any questions?
No, sir.
All right, and Mr. Cromwell for Ms. Latham?
No questions, Your Honor.
All right, any redirect, Mr. Abadi?
I got it.
Can this witness be excused?
Yes, Your Honor.
Thank
Is there a way that we could potentially ask for you for that date if you can get it?
The question is, you want the exact date that the meeting occurred?
Yes, if you can get that.
And I'm wondering if we can, if it's really material, the exact date rather than just its proximity to the November 1st hiring. Is that fair? If he knows whether it was far earlier in the year versus maybe closer, would that obviate the need for the exact date?
If you can't get the exact date, of course, we'll take the best we can get.
Okay, let's start there.
All right. Let me
I think, well, he may take care of it for us just if we hold in place here.
I'm not sure I think this.
Well, let me try this first, Governor Barnes, before you do a deep dive in the email there. Do you recall what time of year it was when this meeting occurred?
I'm afraid not.
Okay.
I mean, you know how this is. The cases and the days moved together. I had a fellow a few years ago that said I represented him in 1978, and I told him I'd take his word for it.
Now, you wouldn't, I gotta ask, though, you wouldn't do that if it was a question of him saying he just hates you.
No, I would not. I will tell you, I believe lawyers should be well paid, Mr. Senator.
All right. So, sir, is that something?
I'll have to look. It didn't come up right.
Okay. All right. We'll ask this witness to step down, subject to recall, and that might be something the state can present with stipulation as well. All right. Thank you, sir. Do we have an update on Mr. Bradley?
Lawyer should be here. He's probably outside.
The last estimation I heard was about 11:30.
Okay. If that's still the case, then Ms. Cross, did you have another witness available?
But having brought over, it's Mr. John Floyd, not the special prosecutor, John Floyd. John Floyd, Mr. Attorney Willis's father.
Okay. And is he heading this way?
Yes.
All right. Consultation later. All right, thank you, sir. At this point, I think we've got something else that can occupy our time, and I think we need to move forward with that. All right. Of course. Yeah, absolutely.
And I didn't learn about the equipment.
Right. Okay. Understood. Ms. Cross.
Mr. Abate will,
Mr. John Floyd.
Mr. Floyd, if you could have a seat, sir.
may I approach the witness quickly?
Thank you. I do.
Please state the spelling full name for the court.
My name is John Clifford Floyd III.
Say, good morning, sir.
Good morning.
Can you tell the court, are you currently retired?
Yes, I am.
And prior to being retired, can you tell the court a little bit about, did you work in the legal career? Were you a
I
lawyer?
was an attorney. I practiced law. I've probably tried 1,000 cases. About 50% of my practice was criminal law. 25% of it was family law. And the rest was whatever walked through the front door could pay for it.
Okay. And
Can we wait 1 second? Governor's come back. He might
I
have.
do. My calendar shows it was October 26th, 2021.
All right. And would defense counsel accept it as a stipulation, or is there any follow-up questioning needed on that? Mr. Barnes is still considered under oath on this point. All right. I would look for a show of hands or for someone to speak now on Zoom, and hearing none. Thank you, sir. You're excused.
And sir, can you tell the court, are you from Atlanta?
No, I grew up in South Central Los Angeles. I spent most of my legal career. I would say in Washington, D.C. was kind of the circle, but I've tried cases all over the country, and I tried the longest. I was the first lawyer to try an international criminal court. I was with the International Criminal Tribunal for Rwanda. I was in trial there for 4.5 years in Arusha, Tanzania, and Hague in the Netherlands.
Okay. When you weren't there, sounds like your kind of center of gravity was Washington, D.C.
Correct, but I've tried cases in West Virginia, Maryland, Florida, California.
All
yes.
over.
Yes.
And do you, sir, can you tell the court, do you have any children?
I have one daughter, Fani Willis.
Okay. And I want to direct your attention back to 2019, okay?
Yes.
Back in 2019, can you tell the court, did you move here to Atlanta?
I was living in Johannesburg, South Africa. And unfortunately, for some reasons, I could not get an extended visa. When I retired from the practice of law in 2018, I moved to South Africa. And I had to leave South Africa, and I did then come to Atlanta.
Okay, and do you, sir, remember about the time period in 2019 when you moved in with your daughter here in Atlanta?
It would have been the spring or summer of 2019.
And after you moved here, did you get a driver's license to kind of confirm your residency in Atlanta?
Well, my driver's license for the District of Columbia was going to expire on my birthday, which is in October. And yes, I did get a license here in the state of Georgia.
Your Honor, may I approach the witness?
Good.
If you would just take a look at what's been marked as stages.
Okay, Your Honor, would you, if you don't mind, my eyes are very bad, which is one of the reasons I retired. And so I need a magnifying glass, so I'll be
Whatever you
constantly, thank you. Yes, I see it was issued on 9/28/2019.
Okay, so before we get there, do you recognize State's Exhibit 2?
Yes, just my driver's license.
And is State's Exhibit 2 a fair and accurate copy of your physical driver's license?
Absolutely.
This time, Your Honor, the state would tender what's been marked as State's Exhibit 2 into evidence.
Seeing no other objections, it's submitted. State's Exhibit 2 is submitted for the record.
Now, and for the record, Your Honor, the state is going to supplement State's Exhibit 2 with a redacted copy of the license. The current copy is not redacted with the address and things of that
All
nature.
right. And do we need to mark that differently in any way?
I will mark it as State's Exhibit 2A.
Perfect.
Now, you talked about when your driver's license was issued. Can you tell the court when was that driver's license here, your Georgia driver's license issued?
It was on 9/28/2019.
Okay, so September 28th, 2019. Now, when you moved into District Attorney Willis's home, who lived there?
Well, my daughter lived there. I lived there, and from time to time, my grandchildren would come.
Okay, and did your grandchildren, were they at school coming and going?
Exactly. I think they were in school in various jurisdictions.
And during the time, how long did you live at or with Miss Willis and at her home here in Fulton County?
She was forced to move after she was elected. I don't know if you want me to go through the whole thing, but that, Your Honor, if Your Honor will indulge me. After she was sworn in on January 1 of 2021. And on or about the 3rd of February, at probably 5:30 a.m. in the morning, there were people outside her house cursing and yelling and calling her the B word and the N word. And just, it was bizarre. Okay. It just.
Sorry. Pause, sir. Mr. Abani. Here's the objection to you.
I would say it's a effect on the listener. He was present while all of these things were occurring, but I can.
No, that's, and he's saying he was personally present to hear these things?
Yes.
Okay, overruled.
Okay, and fortunately, the neighbors called the police and disbanded, disbanded the group, and it was just, it was just, I hadn't seen anything exactly like it before.
Okay, and after that happened, can you tell the court that Ms. Willis would have to move from her home?
Yes, she was forced to leave.
And can you tell the court after she was forced to leave, shortly after she was sworn in, did you remain at her home in Fulton County?
Yes, I stayed there really until 2022, I guess.
And from what you described, did you fear for her safety?
Absolutely. I mean, not only did I do that, I mean, the South Fulton police, they brought somebody, a man with a dog, because there have been so many death threats. And they said they were going to blow up the house. They were going to kill her. They were going to kill me. They were going to kill my grandchildren. I mean, on and on and on. It just, it became, and I was concerned for her safety.
And after those concerns came to your attention, and after what you heard and saw that day, you remained at the house?
Yes.
And can you tell the court, with what you just described, why did you remain living at the district attorney's home here in Fulton County?
Mr. Buck?
I believe it's relevant based on a lot of the questions that were asked yesterday of Ms. Willis as to about the security threat and the fact that it was implied that those threats were not necessarily real in the sense that Mr. Floyd remained in the home. There were many questions about the fact that he remained and her children could still come and go to the house. I think it's relevant based to the testimony that was elicited from defense counsels yesterday.
Overruled.
Well, these South Fulton police, first, they put a car in front of the house that was there permanently, a police car. That was thing one. Thing two, they brought a person with a dog sometimes more than once a day, twice a day, and they would circle the house to look for bombs. I knew that was a house that my daughter had worked for. It was a brand new house. She's the only one who would ever live there. It's a 4-bedroom, brand new house. And somebody needed to protect the house. And I stayed there to basically take care of the house, to take care of the yard, to take care of that. Also, somebody sprayed, again, the B word and the N word on the house. And I don't think my daughter even knew that. I cleaned it off and called the police, and South Fulton police. They have, I'm sure, all the records of all the things that happened. And all of the neighbors, I notified all the neighbors to look out and to watch out. And it was so crazy. I mean, it was just so crazy. We'd have people would show up and park car. There was a guy parked for probably 8 hours out in front of the house. It was just, and we'd call the police and,
Now, at the time that you lived there with Ms. Willis, and I guess even when you remained, so during the time period of 2019 to the end of 2020, are you aware if Ms. Willis was dating someone?
Yeah, she did. She had a boyfriend when I first got there.
And did you meet her boyfriend?
Yeah, I met him often.
Okay, and did you know him by any specific nickname?
Yeah, Deuce.
Okay, and can you tell the court while you were living there, how often would you see him?
Sometimes every day, sometimes, every other day. He was a disc jockey or something, and he had all this paraphernalia that I'd have to move out. It was a thing with the keyboard, things that play music and so forth. So.
Now, when you moved in 2019, and then throughout the years in year 2020, 2021, had you ever met someone named Nathan Wade?
I did not meet Nathan Wade until 2023, about a year ago, when a reporter by the name of Issakoff interviewed me. That was the first time I had met him.
You said that was in 2023?
2023, right?
And I know you said you hadn't met him until 2023, but when you were living at Ms. Willis's house in Fulton County, did you ever meet Mr. Wade in the year 2019?
Absolutely not.
How about in the year 2020?
Absolutely not.
Did you ever see Mr. Wade at Ms. Willis's Fulton County house in the year 2021?
Never.
And is it your testimony that the only time or the first time that you met Mr. Wade was in 2023?
Let me say something. Mr. Wade said that he remembers seeing me, and I do remember some banter. I'm a member of Kappa Alpha Psi fraternity, and there's kind of this thing that goes on between fraternities. And Mr. Wade is a member of Alpha Phi Alpha, and I do remember there was some kind of banter when my daughter was sworn in to be district attorney between me and a couple of guys, and he said he remembers me. I don't remember him.
And prior to that experience that you're talking about, as well as, I guess, your official meeting in 2023, had you ever even heard his name?
No, never.
I don't think I have any further questions, Your Honor.
Ms. Merchant?
Yes, thank you. How are you?
Fine. How are you, counsel?
Good, thank you. Just got a couple questions. On Monday, we heard you were in California. Do you have a place in California?
People always ask me about where do I live. I guess I live right here, sitting in this seat right now. But yes, the answer is I have a place in Los Angeles.
Okay, you do. All right. So do you share time or split time between Los Angeles and Georgia?
Actually, I'm working on a documentary film, and I'm supposed to be being filmed not for this trial, but I'm supposed to be being filmed right now. It was planned, and we had to stop it because they asked me to come here. But the answer is I'm working on a documentary, and I'll be in California until I finish the documentary, if we don't have another actor strike and we don't have another writer strike.
So do you own property in California?
No, I don't. I live with a friend of mine.
Live with a friend of yours. Okay.
Yeah.
And when did you first move? Well, let me qualify with the dates. Did you spend any time in 2019 in California?
No, and the reason I didn't is that when I first came here, the answer is no, I did not. What happened was COVID. Once COVID hit, I was just paralyzed. I couldn't go any place. I couldn't go anything. I mean, I'm a theater buff. I used to go to theater at least once a week. But when COVID hit, I just couldn't. I couldn't go to the dentist, which I need to do. Or, it was just a thing. So I was just stuck. I was just stuck there.
I may be wrong, but I believe COVID hit in 2020. So I was asking about 2019. In 2019, did you spend any time in California?
Before COVID was even here in the United States, remember I lived in South Africa and I've traveled the world. I knew COVID was coming before. I knew COVID was around before. They may have announced it in 20, but in fact, I knew about it and I knew what was happening in 19.
Okay, so let's walk through 2019 then. You said you moved here in September. So
no, I didn't say that. I moved here probably prior to September. In September is when I got the driver's license. I probably moved in the springtime.
I'm sorry, you did. You said spring, summer. I see that in my notes. So spring, summer 2019 is when you moved here. So up until spring, summer 2019, where did you live?
I lived in Johannesburg. Well, I lived in Washington, D.C., 2018. I had planned to retire for the rest of my life in South Africa. I had worked for Nelson Mandela and the Free Mandela and getting that. And someone I'd gone to law school, he had located there after Mandela was freed from prison and became president. I was going to live there for the rest of my life, but unfortunately, because of political reasons, I could not stay in South Africa, and I was forced, in a sense, to come back to the United States.
Okay. So let's just focus in on the period from, let's just start with October 2019. Okay, we'll call that the relevant period. October 2019 until the end of 2019. Were you in Georgia every single day of that year?
Absolutely.
So now let's move to 2020. Okay. And every single day, before I move on, every single day in 2019, you slept at your daughter's house, correct?
That's correct.
Okay. So let's start in 2020. All right. So 2020, the entire year, did you travel anywhere?
No.
You didn't travel at all that year?
No.
So,
And I didn't go to the movies, which upset me also.
So that entire year, 2020, you remained here in Georgia?
Right.
In 2021, did you do any traveling?
No.
So when did you move back, or when did you start this documentary film in Los Angeles?
What I had been doing to occupy time was I was writing my own memoir. As I delved into my family background, I discovered something, and that's what got me to working on the documentary. So I want you to understand what was going on in my life. I pitched I have a movie script called Bad Blood. I have a movie script we're trying to sell. So I tried to sell that, and I just happened to mention something that happened during the civil rights movement. SNCC, it's called the SNCC 5. The legendary Peter Fitzsimmons was interested, and so with Peter Fitzsimmons and Leah Smith, we're now doing the documentary. So
I don't want to interrupt you, but what I was asking was when you moved to Los Angeles, not what you moved there for.
Well, you keep saying moved. I haven't moved to Los Angeles. I spent more time in California, in Oakland, if you really want to just be, because Peter is basically San Francisco based. So we're working on the documentary.
Okay.
I was in Los Angeles because I was going to the Pan-African Film Festival. And that's why we were there. And the way Hollywood works is, you know, when you make connections, and film festivals are a place to try to sell ideas and meet people and organize things.
You still own property in Washington, D.C., correct?
No, I don't.
You don't own property at 1467 Roxana Road Northwest?
That's where I used to live.
That's where you used to live. Did you own that property?
Yes.
Okay. And you owned that property when you moved here in 2019?
Yes.
And you owned it in 2020, correct?
Well, you talk about a very complicated issue. I left the property. There was a dispute between me, and I had gotten a reverse mortgage company. And there was a dispute between me and and I just, I walked away from it.
Okay. You walked away from it with almost $300,000?
Yeah, what is the relevance of that?
Where he lived and registered to vote. That's what they brought in. So that's.
Why is the money he got from the sale relevant at all?
It's the only proof I have of that he owned that address. So I can move on now. Okay. When did you sell that property?
I didn't. The reverse mortgage company took it.
Oh, okay. So in 2019, when you got your driver's license here,
Yes.
the next day you registered to vote, correct?
I think it may have been the same day, but maybe it was the next day. I don't remember.
But you didn't own property here in Georgia that day?
No, I was living with my daughter.
You said that you met Mr. Wade, that you remember you met in 2023, right? That was the first time you
Correct.
remember? Okay. And I wasn't really clear. You said something about meeting him. Was it with Mr. Isikoff, or did Mr. Isikoff tell you?
No, I was being interviewed by Mr. Isikoff.
Okay.
And he walked in, and I met him. That was the first time. He walked into the office. And
where were you being interviewed?
at the district attorney's office.
And Mr. Wade walked into that interview?
Yes.
And so Ms. Willis had not told you about Mr. Wade prior to that?
Absolutely not.
So she didn't tell you anything about their relationship before you met him that day?
No.
But Mr. Wade remembers meeting you in 2020?
He said that at my daughter's swearing in. I do remember that we having some banner about fraternities, but other than that,
Oh, at your daughter swearing in, okay.
right.
That's all I have, just one moment. Judge. Nothing else, thank you.
Morning, sir.
Good morning. How are you, counsel?
I'm fine. I'll try to ask you some specific questions if we could, okay?
And I'll give specific answers if I can.
Perfect.
Okay.
The driver's license address, I'm not going to publish, that is State's Exhibit number 2. But is the address on that driver's license the home that you're referring to as your daughter's in South Fulton?
Absolutely.
Okay. It was unclear to me, maybe no one else, but it's unclear to me, when did you stop living at what I would call your daughter's home in South Fulton?
Things got so bad and threats got so many, even against me, that the house became basically uninhabitable. I got tired of sleeping in one room one day and no one that. I would say December of 2022, something like that.
December of 2022.
Right. That's about right. Yeah.
Now, let me change and go back for another date. You had indicated, and I didn't hear it. When was your daughter, Miss Willis, when was she sworn in as district attorney?
On January 1, 2021.
Okay. And did you indicate that there was an incident, and I know you've described it, was that incident on February the 3rd, 2021?
That's my best recollection.
Okay. So my question then is, after February 3rd of 2021, how much longer did Miss Willis stay at the house before she moved somewhere else?
Very short period of time, and I cannot be precise, but I would bet all the money I ever made, it wasn't more than a month and a half, if that long.
Okay, so we're talking about, best of your recollection, end of February into the beginning of March, give or take, of 2021, when Miss Willis would have moved to a different location.
Exactly.
Okay. And did Miss Willis return to the house, that is, the house that you were in, at any point in time that you can remember?
From time to time, she and her security might show up for her to pick something up or take something or something, but she always would come with her security.
Okay, my question was poorly worded, I apologize. Did she come back permanently to her house?
Oh, absolutely not.
Okay,
Absolutely not.
So as far as you're aware, that once Miss Willis left the house, her house, South Fulton House, so the record's clear, in either late February or into March of 2021, best of your recollection, she's not returned to that home to live.
No, it became uninhabitable. It just,
That's okay.
I would have to walk around that house looking out of every window. I made a habit of having to walk around the whole house. I got lights so that if somebody would come at night in the back, so that those kinds of reflecting lights, I had those put up.
I don't mean to again to cut you off.
Okay.
All I was interested in is whether she had ever returned.
No, the answer is no.
Okay. Now, when Miss Willis, when your daughter left the home, time period, end of February, beginning of March, give or take, 2021, do you know where she moved to?
No, and I didn't want to know. I intentionally did not want to know because I was not, if somebody stuck a gun to my head and I could tell them, I wasn't going to tell them anyway, or I'd have made up something, but I didn't want to know.
Okay, so would it be fair to say that if you didn't want to know, you never visited her at the place that she moved to?
Oh, I never did.
Never did.
Never did.
Okay. Do you know how long she stayed at the first place that she went to after she left her house before she moved to a second place?
What I know, and this is hearsay, counsel, is that my daughter has had to move something like 4 times.
But do you know any potential?
No, I don't know any place. I was taken one time for Christmas Day. I've only seen my daughter, and this is very hard for me to say, but During the period my daughter left, I've only seen my daughter 13 times because I can't, and we've never seen each other more than maybe 3 hours because of, the nightmare threats against her and me.
And I understand that. And from the perspective of being a father myself, I understand what that means. So I'm going to move away from that. I was just trying to get an idea of date wise. Okay. So let me try to get one more date. In 2023, when you were being interviewed by one of the gentlemen that wrote the book at the DA's office, and Mr. Wade came in, can you give us, other than 2023, what the date would be?
I'm sorry, I can't, Council.
How about spring, summer? Any idea?
I would guess spring or summer, but I can't.
Okay.
I don't. I'm sorry.
And you've already indicated, at least to your recollection, that was the first time that you'd met Mr. Wade.
Oh, absolutely.
Okay, I'm not arguing with you about that. I want to go to Miss Willis's boyfriend that you referenced. Okay, you met Miss Willis's boyfriend, as you've characterized it, when you came here in 2019.
Correct.
And you met him on one occasion, several occasions?
Oh, no, I saw him often.
Oh, so you mean there was no secret that she was dating this man?
Not from me.
Not from you.
And he was a disc jockey of some kind. I think he had a government job during the day. I don't know what it was, but apparently he would do weddings and so forth and so on. He was a disc jockey, play music. So he had all his stuff was always in the way, and I was always having to try to push it aside. And, anyway.
But Miss Willis, your daughter didn't keep him from you, correct?
No.
No, I mean, there was no doubt.
My daughter and I lived in the same house. I mean, he came and went,
Right. Now, when did you learn that your daughter had a romantic personal relationship with Mr. Wade?
Well, about 7 weeks ago when as a matter of fact, I just found out when other folks found out. Okay.
That is, your daughter, as I understand it, never told you one time in the year of 2022 that she was dating Mr. Wade, correct?
That's correct.
And until recently, you didn't know from anyone, including your daughter, that she dated Mr. Wade, correct?
That's correct.
That is, whatever the relationship is between father and daughter, she kept that a secret from you, correct?
Correct.
That's all I need to know. Mr. Stockton.
No.
Good morning, Mr.
Good morning.
Correct.
Good morning, Council.
When your daughter moved or left the house that she owned, did she say anything to you about having a large savings of cash?
Oh, no, no. See, maybe, excuse me, and Your Honor, I'm not trying to be racist, okay? But it's a Black thing, okay? I was trained, and most Black folks, they hide cash or they keep cash. And I trained, you always keep some cash because I've been places, and just because of the color of my skin, for example, I took a fellowship at Harvard when my daughter was just, if I might, Your Honor, when I was just, she was just, maybe 3 years old. And I remember going to a restaurant in Cambridge, Massachusetts, and I had a American Express credit card and maybe a Visa or whatever. And I had a lot of what they call traveler's checks. I don't even know if they still have traveler's checks, but traveler's checks. And there was a sign said, with the credit card. For whatever reasons, the man would not take my American Express credit card. So I pulled out my Visa card, and he wouldn't take my Visa card. So then I pulled out my traveler's checks. He said, we don't take checks. Now these were traveler's checks. This was money. I had a $10 bill. I'll never forget this as long as I live. And he said, the bill for my wife at the time, Fani's mother, Fani, and myself was like $9.95, and I had a $10 bill. That was all that. I always remember that. But even before that, I've always kept cash, and I've told my daughter, you keep 6 months worth of cash always. For example, I had 3 safes in my house. I put some of my clients' stuff there too, things I didn't want other lawyers to be, because you're always in a firm, and I knew that there were special conditions. So some of my clients' things I would bring home, put them in the safe. But I've always kept safes. And as a matter of fact, I gave my daughter her first cash box and told her always keep some cash.
So is that a yes?
Yeah. Oh, absolutely.
That's all I got, Judge.
Mr. Durham,
No questions.
Mr. McDougald,
No questions, Your Honor.
thank you. Mr. Rice,
No question, Your Honor.
Mr. Gillen.
It's still morning. Good morning, sir.
Good morning, Counsel. How are you?
Just fine. Just a few questions following up. When you were talking about when you learned about Mr. Wade and your daughter, correct?
Correct.
Now, did your daughter tell you in around October of 2022 that she had gone on a Caribbean cruise with Mr. Wade to the Bahamas?
The answer is I knew that my daughter had gone, but I did not know who she went with or what the circumstances were. So I knew that she had gone out of town, but I didn't know with whom.
I see. And did she tell you in November of 2022 that she had gone to Aruba and stayed at a Hyatt Regency resort there in Aruba for 3 days with Mr. Wade? Did she tell you that?
The answer was, again, I knew she went out of town. I didn't even know where she went. I knew she was going out of town. She told me she was going out of town. I think she might have said she was going out of the country or something. She'd be gone. But other than that, that was all.
Okay. And did she tell you in March of 2023 that she was going to Belize for several days with Mr. Wade?
The same answer, that I knew she would tell me she was going out of town, and she may or may not have told me where she was going, but she'd be gone for a couple of days.
Okay. Now in 2023, you were in many days you would be out in California, correct?
Some days I'd be in California, correct.
Okay. Well, did she tell you in May of 2023 that she was traveling to Napa Valley with Mr. Wade, so maybe y'all could see each other when she visited California with Mr. Wade?
The answer is no.
And so the first time that you ever met Mr. Wade or learned about Mr. Wade, to your recollection, was in 2023?
That's correct.
That's all I have, Your Honor. Thank you.
Mr. Kachuroff on Zoom.
Yes, Your Honor, just a couple quick questions. Good morning, sir. I know I can't see you.
I can't see you either,
We
but
can take a moment.
good morning, Counsel.
We can take a moment. Let's just pause, see if we can change the screens to show Mr. Kachuroff. Sorry. We need,
Your Honor, I'm on a phone, so it's kind of difficult.
can you turn your screen on now?
I'm trying to. Does that work?
Just to hold one more moment? All right, there we go. You can proceed, Mr. Kachuroff.
Sir, you seem to know about the issue of cash in this transaction. You said it was a black thing. How did you know that the cash was going to be an issue in this testimony?
Because I was asked for it and I was prepped by the lawyers and they asked me about it. What else?
And did you speak with Mr. Wade about your testimony?
No.
Did you speak with your daughter about your testimony?
She may have been present when the lawyers were. I really don't remember.
If Mr. Wade and your daughter were dating, you wouldn't have known that unless your daughter told you.
What do you, maybe I'm not understanding your question, Counsel. So maybe you want to restate. What is it that you're asking me?
Yeah, if it wasn't clear, I can re-ask the question. I'll rephrase it.
Yeah, right, yeah.
Mr. Wade, If Mr. Wade and your daughter were dating, you wouldn't have known that unless your daughter told you.
I did not know that they were dating. And when
Okay.
were you talking about the cash? I didn't know that. I don't know what you're asking me. What I told my child from the time she was a child is always have some money. Always have some money. If you go on a date so that people don't try to stick you and you want to leave whoever, always keep some cash, okay?
Mr. Floyd, you answered the question that the attorneys prepped you for that. So that's all I wanted to know.
Anything else, Mr. Sheriff?
That's it, Your Honor.
All right, Mr. Cromwell.
No questions, Your Honor.
Mr. Abadi?
Your Honor. Mr. Floyd, now, it wasn't common for your daughter to confide in you about her romantic life at all.
No, and I haven't confided in her about mine before when I had one, okay?
And you wouldn't have known about her boyfriend, the disc jockey.
Hey, Debs.
Is that an objection?
I think that might have just been still off mute.
Okay.
Let's keep going.
Now, you wouldn't have known about her boyfriend, the disc jockey, had you not been living with her, correct?
That's correct.
I'll allow overruled.
I have nothing further.
Did he answer the question?
He said that's correct.
All right, by show of hands, any redirect on those points only. Ms. Merchant.
I just want to know when you were prepped by the lawyers, when this prep session was.
I just got off the plane on, what was it, Tuesday night? I think I was probably drooling at the mouth. I was so tired. So it must have been, I got in Wednesday. It must have been Wednesday.
Okay. And did you talk about any of the testimony from yesterday or watch any news reports or anything like that?
Oh, absolutely. You can't cut the TV on without seeing this. The first thing, and I listen to conservative radio a lot, and, last night for 5 hours, all they talked about was this case.
So you were aware of what the testimony your daughter gave yesterday was?
Yeah, unless you don't cut the radio on, unless you don't cut the television on, unless you don't read the AJC or any other, the New York Times or whatever, which I do every day, of course.
So is it fair to say nobody instructed you that you were under the rule of sequestration?
Right, and I'm not under subpoena either.
Thank you.
All right, anything else? Seeing and hearing none, thank you, Mr. Floyd.
Thank you very much, Your Honor. It's a pleasure to appear in front of Your Honor.
Thank you. All right, Ms. Cross, let me check in. Was the state planning to call additional witnesses?
Not at this time, Your Honor. We're again trying to accommodate if there's a
Sure.
license scheduled to be able to this afternoon. But right now, that was last witness.
Okay, so even if Mr. Bradley testifies to some extent, it's still the potential that the state has no further witnesses?
I anticipate at least one more will be available this afternoon, but that would be it.
Okay, so there are potentially more state's witnesses. All right.
Before we move on, I move to strike the last witness's testimony.
All right, so I think the rule is invoked and the instruction was for the parties to tell all witnesses subpoenaed or expected to appear about the rule. I don't think the remedy is necessarily striking. I think it can go also to this credibility as well. So to that extent, unless Ms. Cross, you want something else to be heard on that, point is made. All right. Do we have an update for Mr. Bradley?
Yes, Your Honor. Yeah, he should be here at 12:20, 12:25.
Okay. Then what I think we should do is have these preliminary
Good afternoon, Mr. Bradley.
Good afternoon.
Before I begin, I wanted to ask you if you wanted to clarify any of your statements that you made yesterday.
Go ahead and begin.
I wanted to ask if you wanted to clarify any of your statements that you made yesterday.
Go ahead and ask whatever you're going to ask, Ms. Merchant.
You initially became involved in this matter because you called me. Right?
Absolutely not.
I didn't call you.
No, it was through a third party.
You called me after you read an article and I don't even know where it was. I found one in the Washington Examiner. I've got an objection. Can we approach the bench?
Okay.
Well.
But I can alert the court broadly to my concerns. This witness, it appears from the questions that Ms. Merchant had proposed, don't differentiate between what I'm considering three kind of buckets of information that this witness might have. One is communication derived from his representation of Mr. Williams. Second is any information that he might have from personal knowledge. The third category, which I believe is the substance of what Ms. Merchant wants to go into, is information not derived from personal observation, not derived from communication with Mr. Wade, his client, but gossip, secondhand, thirdhand, speculative things. Ms. Merchant's questions don't differentiate those categories of information. And I'm concerned about the questions being proposed without that qualification so that Mr. Bradley doesn't know when to invoke the privilege. I think the testimony yesterday was he didn't have any personal knowledge of any of this. That was my understanding of the testimony. I believe that was Mr. Bradley's sworn testimony yesterday. And my concern is that the gossip part, the unsourced hearsay is where we're going to get to really fast.
Sure. And I think that's a fair point. I think she's following the script that she already provided you. So we have more than enough notice of when that might be coming. I think the second she asks a question that you think might weigh into that, make the objection and we can rephrase if necessary. All right, Ms. Merchant, you can re-ask that last question.
Read an article that was published September 11th discussing how much you and Mr. Wade were handling me, correct?
That is correct.
And you called me that same day and left me a voicemail on my cell phone asking me to call you back.
I do not recall that, but I do not recall that.
You don't recall that?
I do not.
So it's possible that happened.
I do not recall calling you after the article came out. I was shown the article, but I do not recall calling you after the article.
Can you tell us your phone number?
It's 334-717.
Wait, hold up. Why is that relevant, Ms.
Yeah.
Merchant?
Because I need to establish that his phone number is the one that all of the texts that he had with me.
Can you just ask him if he has texted you at some point? We can stipulate that as a matter of record. We don't need that on the record.
Okay, we don't have to put it in the record. How about this? Can I show him a copy of his what he saved in my?
Sure.
I'll just do that. Now approach touch.
You may.
Take a look at that and just verify if that's your number and your cell phone.
That is my number and my cell phone.
Okay, and is that also your email address?
That is my email address.
Okay, great. Thank you. And I'll keep that separate, Judge, and we can redact it. So after whether or not you left a message on my voicemail, the next day, we were all in court in front of Judge Harris on September 12th, 2023. And how do you recall that?
I do recall being in Judge Harris. Yes, I do.
And your attorney, BC Chopra, was there, and I was there, and another attorney, Burt Cohen, were there, correct?
Those people were there at the time. BC was not my attorney. I didn't realize I needed an attorney until I was subpoenaed.
But BC Chopra was there. I'm going to object to the relevance of this.
Ms. Cross, as I see this line of testimony, much of it is I'm taking in response to the original, how we started off this whole hearing, that Ms. Merchant had no basis whatsoever to bring this and she should be sanctioned. And I think she's laying that out. Okay. All right. Ms. Merchant.
I recall it was in a conference room in the front. I don't know. I know you were handling a case in Judge Harris. I think I was speaking to Burt about a case, and BC was there to speak to Burt about a case. Yes, I think I do recall that happening, but I can't recall who else was there. It was a regular court date.
That conference room, that's sort of in Cobb County, there's a conference room in the front.
Correct.
And it's not a public room, it's sort of like a jury room.
Correct.
And it was the four of us in that room talking.
I don't recall if anybody else was there. I will say that I do remember at some point it was myself, you, BC, and Burt there, but people were coming in and out of the courtroom, so I cannot sit here and accurately say that somebody else wasn't there at the time.
Correct. And based on that phone conversation, I told you I had been submitting open records requests and I was going to continue to submit open records requests, correct?
Based off what phone conversation?
Based upon our conversation in court.
Oh, okay. Correct. You said that you were doing some open records requests, correct?
And then based on our conversation, I told you I was going to do some additional open records requests.
Which open records request are you talking about?
Just any. I'm just asking if we talked about that I was going to be doing some follow-up with Fulton County.
Because I recall open records requests being made for other things, and so I don't know which one that you're referring to.
At that time, we talked about getting, I guess it's called a county card and getting access cards and things like that for coming in and out of Fulton County for you, Mr. Wade,
Okay.
and all of the access that you all have to
Yes,
the office.
yes. And you asked me, did I have an access card?
And you are the one that told me that you and Mr. Wade, or that Mr. Wade at least had an access card.
I told you that the three of us had an access card because we had a contract with the DA's office or the county. I told you what those contracts were and that we had an access card that will allow us to pick up the documents, go into a specific office, and leave out.
Right, okay. And so we talked about that badge access card and asking for that, and I was gonna ask for that, right?
Correct.
And then a couple days later, I sent you a text, and when I say a couple days, so that was on September 12th when we had that conversation.
Do you mind if I pull out my phone?
Not at all. On September 14th, at 6:38 PM.
And what day was this?
It was September 14th.
September 14th, correct.
And I sent you a screenshot of a Fulton County open records request I did.
Yes, and I said, wow.
And then, we continued to text.
Wait.
Okay, sorry.
And then you sent another text about a badge, and I did not respond. You sent another text about an entrance card. I did not respond. You sent another text about some other badges and with a circle around it, and I did not
I
respond.
object, Your Honor.
Okay.
I'm sorry, thank you.
All right. Mr.
I-
Bradley, if you could just respond to the question asked and only the question asked.
That was
Thank you,
actually, I have an additional.
Okay.
Thing I want to raise. Ms. Merchant provided some text messages that she let us know that she was going to refer to. The text messages are inconsistent with Mr. Bradley's exchange as he apparently is reading it off of his phone. So if I could ask Ms. Merchant, is this it is true, accurate, and complete? And perhaps we can see what's on Mr. Bradley's phone. But more importantly, I am going to object. I understand the court's leeway about
Sure.
being able to establish contact based on previous statements made. But I'm concerned about going into the content of the statements without putting things in the buckets that I've identified.
Sure. And so am I, Ms. Merchant. I'm not seeing so much the relevance of it back and forth. I'm allowing you to establish, the contact that was made and line with the outline you provided me. And I think we're on track with that. Were you planning to tender these text messages?
I was planning on discussing them with him. Now, if yesterday he said we didn't text about this case, so if that was his testimony again today, then yes, I would show them to him to refresh his recollection or to impeach him. But their first part of their argument is foundation, is what I'm assuming. They're saying all of these. They're not all relevant. I can give you all of my texts, but they're not all relevant. And so they asked for screenshots, and so I took screenshots. If there's a way to submit my entire text history for Mr. Bradley, then that's fine. If they want us to read every single text, that's fine. I just don't want to be in a position where people are saying that I'm not.
Well, I also want to avoid the situation where you as counsel of record are having to just lay the foundation and do that sort of thing yourself. So I don't know how much further we can go with this before we get into that. So
Well, I'm not sure what their objection is. So I asked him about one question and he read off
sure.
several other.
Why don't we just go with your next question and we'll see where we go from there.
All right, let's move on.
But, so,
Mr. Bradley, when you wait for her to ask a question.
and I understand that, Judge, and I'm not
Well,
trying to.
apparently you don't, sir. Wait for her to ask a question and you'll have a chance.
So I think the last thing I asked you was about September 14th. So those texts that you're talking about, those refer to the issue that we're here today about though.
Some text said yes.
Yes, okay. And then you called me again on September 15th, 2023, and we spoke on the phone.
I do not recall that.
Well, I texted you and said I needed to call you back, and then I later called you back.
I'm not sure. I do not recall.
You don't recall that? Okay. And do you recall the following Monday?
Your Honor, I appreciate the question as it is on the form, and if the question is what she's going to read, I object to it even being asked out loud without knowing, number one, the relevance of it. If the witness is going to answer the source of information, and I feel like it is so inflammatory as to say out loud without knowing where Mr. Bradley falls on that, then I do have an objection to the question.
Okay.
All right. With all due respect, if I might just a moment. Why is it that we're not allowed to ask a question? And then when the question is asked, there's an objection made either by the state or the lawyers for this particular witness. It appears that what the state would like to do is force us to tell you in advance every question we're going to ask before there's an objection raised. And I don't understand why they get to do that, but we are obviously in the same position to say to them, tell us every question you're going to ask first. I realize it's a privilege, but that can be the questions asked, state objects, Chopra objects, and the court rules, but not being able to put it on the record because it's inflammatory or it's somehow prejudicial, I don't think that, I'm just suggesting.
Sure.
I don't think that.
So, Mr. Stan, I'd agree with you in the general sense of things, but in this situation, Ms. Merchant offered to provide essentially her list of questions in advance, giving us a preview of what she's going to say. And that puts us in kind of a different posture in that respect, where we can actually have some sense of what's going to come out. But Ms. Merchant, I think knowing what your next question may be, since usually we don't have that opportunity, does it presuppose some knowledge on his part that we have yet to establish is inside or outside of privilege?
Well, the first thing, Judge, is I gave these questions so that you wouldn't be in a situation where we were objecting and having 4 different lawyers talk about privilege, confidentiality, every single question. So I was hoping that we would ferret that out ahead of time. So this is the first that I've heard that objection to question 18. I did give the state copies of it as well, trying to be completely transparent. I also, I have to establish that his information, there have been statements in this court that I lied, multiple statements yesterday. I can't even tell you how many times that was said under oath yesterday, and that I did not get this information. And so I have a right to
which I've already said we can do and we can go over. But and we've already started doing that. But the next question, as you plan to ask it, may presuppose again some information that he has that we need to determine whether it's inside or outside privilege. Is that right?
No. Well, I don't believe so. No. I mean, if we're going to talk about the privilege, I wanted to talk about it beforehand, which is why I gave all of these. I didn't know the state had objections on these questions to privilege. If we're going to talk about the privilege, I'm happy to ask him the substance of the question, but that is what I'm getting objections for. So I'm trying very carefully to craft something to avoid that. But I'm happy to just ask outright the question.
Right. I don't see a way around that, Ms. Cross.
I understand, Your Honor. I'm going to do whatever you tell me to do. The problem in the context that Ms. Merchant is posing the questions is, this was our communication, this is what I asked you, this is what you told me, and here are these texts that are supporting it. I understand the court's ruling that based on how things have gone, if Ms. Merchant feels that she needs to establish there was contact and communication, then I don't have an objection to that. However, number one, the text message that exchange that Ms. Merchant gave me is apparently not complete. And so I don't know, without making her a witness, how the state can, and we're entitled to, if she's going to refer to text messages, we're entitled to an accurate representation of what those are. Mr. Bradley's looking at his phone and that's what he's got. He is under no obligation. Ms. Merchant provided this to us and I appreciate it. But I can't tell as I'm sitting here to object to an incomplete or an inaccurate recitation if what she gave me isn't complete.
So a couple things come to mind. One would be that anything the witness is referring to on the stand, counsel at any point has the right to inspect. And so if that's what you're asking for, Ms. Cross, then I think you have a right to do that if you decided to do that. The other is as I've seen it so far, I don't think these texts are coming in as substantive evidence, but more for impeachment, in which case extrinsic evidence would never be coming in to prove them up. And he either takes her answer or he doesn't. That's how it works. So I don't see the foundation issue or the completeness issue really playing into it as it comes to impeachment.
And Judge, they asked me for the relevant screenshots. I told them, he doesn't have an iPhone, I can't download the entire text message history. I told him they could go through my phone. Like, this I'm hiding something thing.
All right, Ms. Merchant. I think at this point, again, I don't see anything extravagant about the next question on his face. I think we need to deal with it as it goes. So proceed.
I asked you where I could get an affidavit from about the affair, and you responded no, because you didn't think anybody would freely burn that bridge. Isn't that true?
If you say so. I don't.
Do you have your text if you need to refresh your memory? September 18th at 3:11 p.m. if you need to.
Can you repeat the question?
The question is, did I text you asking you if you knew who I could get an affidavit from about the affair? And you responded no. No one would freely burn that bridge.
Yes, I do see that.
Then I asked you if Chris Campbell did it, correct?
No, you asked me if under oath he would testify.
Your Honor, again, I'm gonna object to the source of the witness's information about that, whether that's firsthand information or not, and Mr. Campbell, of course, has a privilege too.
Well, since Mr. Campbell hadn't even been brought in to this proceeding at all, I'm also wondering about just the relevance of asking questions about Mr. Campbell.
I'm just, it's been objected that I'm not asking about all the texts and I'm selectively asking, so I'm trying to go through all of them. I would much rather just ask the very relevant ones.
Well, I have an objection to her asking. I can't tell if the statements or the testimony provided is consistent or inconsistent without a complete set of this text exchange. And it's not clear in the text exchange what the source of Mr. Bradley's information that he's providing is. And so that is, I'm struggling and I know everybody else is too.
And again, I think you're focusing more on the merits than the impeachment value, right? If the sole purpose this is coming in is on those grounds, then you being able to match them up word for word, I don't see that as being a necessary prerequisite. But as it relates to Mr. Campbell, he's not a witness yet. He hasn't come in. I don't think he's come up really all other than passing and maybe the firm. So why don't we skip ahead to the next questions, and you could always come back to that if somehow he has made an issue in this case.
That's great, Judge. I needed some clarity because the state is objecting that it's not full and accurate. I'm keeping things out, and then they're objecting that I'm putting too much in. So I'm just trying to avoid every question having an objection, Judge. So on January 5th, 2024, we had a text exchange where we talked about that I had discovered that Nathan took Fani on a cruise and a trip and paid for it with a business card. You told me you were on a plane home from Dubai, but you would call me as soon as you got home. Do you remember that?
So what I have is a text message from you saying, "Oh my God, Nathan took Fani on a trip to Napa and paid for it with his firm."
Okay. Continue reading.
And you said, is he that dumb?
Mhm.
And I said, wow, I'm on a plane from Dubai, land at 3. We'll call you as soon as I land.
So that is accurate. That's what you told me.
That I will call you as soon as I land in wow?
Yes.
Yes, that is accurate.
And then you told me that you weren't surprised because they took many trips to Florida, Texas, and California.
Okay, so I don't have that, but, and I can show my phone, but I don't have that in my phone.
So the question is just, do you recall
I do not recall.
communicating that to
I
me?
do not recall.
All right.
Do you recall telling me that it was when she had to move her daughter a trip to California?
I do not recall that.
And Judge, may I approach the witness?
You may.
Thank you. It's in the packet I gave you. Oh, I see. Take a look at that, see if that refreshes your memory.
Yes, I see this.
Does that look like, does it refresh your memory?
It does not. I mean, I see what's on the text chain, but you said this happened January 5th?
I can tell you exactly what happened. Because there's no date and time stamp on that. Let's see. It was, let's see, just. I think it was January 5th. Just give me one
Judge, I just want to, on behalf of Mr. Wade, just to review the question again. We still don't.
To which question?
To the current question, we still don't know the source of this information, whether it was privileged or how we obtained it.
I'm wondering now if there's a timeliness issue on the objection, since he already, well, he said he doesn't recall. So
Right,
there's,
you just gave the date, he didn't
Sure.
start it.
well, his question, or his answer was he doesn't recall, and his memory has not been refreshed. So I think it's time for the next question.
May I approach the witness?
Okay.
Can I see what you're approaching the witness with? So is this the complete text chain?
Yeah, it's a complete text. While they're looking at that, can I just ask you, did you delete any text messages?
I have several messages in the phone with you. I've never deleted. I mean, there are messages about family and health and things like that. You asked me to be on some panel.
Yes.
And so I think it's complete, but
Well, no, my question was, did you delete any?
no, I haven't deleted anything.
Okay.
I have not.
And I offered them to look through my phone earlier if they are welcome to.
You never provided it to us.
Said you.
Physical phone, you never provided it.
It's the only phone I have, Judge.
Yeah. I understand, and I don't want to keep popping up, but my concern, of course, is that these exchanges are just two lawyers gossiping about information. And I'm concerned about it coming into the record in this way. I understand impeachment is a thing, but if we could do it in a way that the substance of this gossip is not, that part is not impeaching, the contact is impeaching. So
I don't think we've gotten to that point quite yet, Ms. Cross, but you can review objection if you think we have. So right now, the sole thing that Ms. Merchant is trying to do is hand an object to refresh his recollection again. So we'll see where we get with that.
And I don't have any way to download it. It doesn't have my phone, so.
May I, one
Ms.
thing?
Shana.
The court is a trier of fact. You're going to be able to determine whether something that has come in, if you choose to, is hearsay, whether it's admissible, whether it's relevant, whether it's impeachment. You're in a position that If it all comes in, but you reserve the right, or all parties reserve the right to object, we can deal with it. This is not a jury. We don't have to worry about the jury hearing something that it will no longer consider. All we're doing now, with all due respect, and I understand there's a process, the state doesn't want something to be heard.
I object to that.
They've repeatedly attempted to stop questioning. Your Honor can hear it all and then decide what is and is not relevant or admissible. We don't have to go through every single one of these. The only time we have to go through this is if it is in fact a communication, and it's a privileged communication, and an argument has to be made at that point as to whether or not it should be elicited or it is subject to being stated in open court. Otherwise, all of this could come to the court, and the court can then decide how it wants to treat it. That's the suggestion.
I appreciate that, Mr. Sayam. I think it's certainly accurate that we could have an approach where if it's a close toss-up on an evidentiary question, we can have it all come in and sort it out later on the record. I don't think we've quite reached the point where I need to do that. I think we still have time to get into these, and it'd be my preference to keep the record as clean as possible and without questionable evidentiary issues. But we may get to that point. So the question from Ms. Merchant was to approach the witness and with an object to see if that would refresh his recollection to the last question asked.
Yes. Now, I'm sorry, the state scrolled through it, so it's not right there again.
No, we didn't move it. Can't move it.
No, I mean, like, it was on the screen. Now I can't find it. I'm going to move on to the next question that I actually can't find, and then I'll find that and come back to it. I sent you a statement and said, upon information and belief, Willis and Wade met while both were serving as a magistrate judge and began a romantic relationship at that time. And you corrected me and say, no, it was in municipal court. Is that correct?
I think it's pretty accurate.
And is that based on your personal knowledge?
But what question, was it municipal court or when they first met, or?
My question was, is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And you wrote, no, that it was municipal court.
Okay. So I answered to Bradley just a second. Mr. Chopra has risen.
All right. Your Honor, I do have one purpose here, and that purpose has now been met. Any information that Mr. Bradley may possess would in fact have come from his representation of Mr. Wade. This falls within the purview of his divorce proceedings, which, as we testified earlier, commenced in December of 2018. There's no pierce or shield associated with it, and so we would say that under Rule 1.6, we should not be compelled to give any further information.
Okay, and as we discussed about before the break, Mr. Chopra, I ruled earlier this morning that this witness is going to be directed to respond to any question to the extent it falls outside of attorney-client privilege and only attorney-client privilege, meaning 1.6 is not going to bar his testimony in this case. What would be your response then?
Then Mr. Bradley would have to consistently assess on his own, unless I'm jumping up and objecting for him, whether or not this came within his knowledge based on his representation. I can say based on the phrasing of the question from Ms. Merchant, it would in fact come within information obtained from his partner client at the time associated with the activity in question.
All right, Mr. Evans, same issue.
I just want to reiterate that it's a compound question anyways, that it sort of needs to be separated out, but it's still based, we just renew the objection that it's still based on gossip, either gossip or privileged communication. He doesn't ever cite the source of where any of this information is coming from, so I just wanted to make that objection.
far as privilege, any privilege objection, it's been waived, particularly for this issue because Mr. Wade
He did testify on this subject.
testified on this subject.
Well, he didn't testify as a communication with his attorney about any subject. He testified factually about what trips he took and events that occurred. He didn't testify, to my recollection, about any communication with his attorney.
But he testified about the subject matter of the question that was just asked, which was when apparently they first met.
Furthermore, Judge, my client wasn't privy to that testimony. We have been under subpoena and therefore under the rules, so we do not know what was or was not testified to. Everything he says would be a violation of that privilege unless we know specifically what all has been waived.
Sure. Unless I make a finding that there was an express waiver on behalf of the client.
Yes.
Right? Okay. Sure. Got it.
So for this question particularly, Judge, we would ask that you find that there has been a waiver of the attorney-client privilege because Mr. Wade testified to something directly different than what this witness, we believe, has knowledge.
Yes, Mr. Wade testified as to when they met. That is not the entire substance of the text message that Miss
And began a romantic relationship.
Yes, he did not testify that they were serving as magistrate judges when they began a romantic relationship.
All right.
He testified differently.
Okay, Ms. Merchant, I think you're going to need to establish whether this witness ever gained that knowledge independently or during the course of a attorney-client relationship.
Did you have any, thinking back to the source of your knowledge, and let me just, before I do that, let me remind you of what is covered by attorney-client privilege. It's communications that relate to matters in which legal advice is sought, and communications that have been maintained in confidence, and no exceptions to the privilege. So it's communications that are in furtherance of legal advice. Your knowledge that their affair began, that their romantic relationship, began while they were both serving as municipal court judges. Is that from your personal information, your personal knowledge, or is that from?
I'm going to overrule that objection, Mr. Chopra. He can answer that question.
State that question again.
Your knowledge?
Is any knowledge, if any,
knowledge of Nathan Wade and Fani Willis's relationship, romantic relationship beginning while they were both serving as judges, is any knowledge that you have from your own personal knowledge or something that was told to you in furtherance of legal advice?
I have no personal knowledge of when it actually happened. I was not there. I do not have any personal knowledge, so I would choose not to answer that question under 1.6.
Mr. Bradley, we made a distinction earlier.
Yes, sir.
That it's a bit narrower than that.
Okay.
1.6 is.
I have no personal knowledge, Judge. I apologize.
Okay.
If you were,
That's not a problem. The issue is attorney-client privilege, and so whether what you learned, if anything, was during communications with the client.
It was.
Okay, Ms. Merchant.
and was it that any knowledge that you had as to the truth of that statement, was it told to you in furtherance of legal advice?
I'm going to object to it. If that statement is true,
That's all right.
and the witness has already testified he has no personal knowledge about that. So whether he represented at one point it was true or not true, he has no personal knowledge about that, so could not testify.
Prior inconsistent statement, Judge. Do it all the time. That is what the state
It's
does
not a
regularly.
statement.
They bring in, if it's a prior inconsistent statement of another witness, Judge. Mr. Wade
Which other
testified.
witness?
I'm sorry.
Okay, Mr. Wade testified.
That their relationship did not start.
But you can't impeach him with a prior inconsistent statement that's privileged. And so we haven't gotten over the privilege hurdle.
The privilege hurdle we've gotten over with fraud on this instance.
Well, yeah, that's the first time you use that word. So if you want to make the argument of why that applies, you can do that now.
Yes, Judge, the crime fraud exception, it applies because of the crime fraud exception.
Which crime and or fraud was committed here?
So there's a couple different things, and I want to just stress them both because he's raised 1.6 and also raised attorney-client privilege. For the crime fraud exception says the privilege doesn't apply if it's if the existence of it, it's essentially if he has to keep something secret to allow a fraud upon the court to continue. So we've got that. We've also got
No, it has to. The legal communications have to have done in furtherance of a crime or fraud. How has that been established? And what crime or fraud are we talking about?
We're talking about perjury, lying to the court.
In the affidavit filed last month.
Yes.
And so what have you done to link the communications that he made maybe, I don't know, years ago to the affidavit filed last month?
The communications even years ago, it's proof of the affidavit being incorrect, being false. He's given a prior inconsistent
But the
statement.
legal communication has to be in furtherance of a crime or fraud.
Right, but he also can't protect, so, and I think it's more under,
So if he had no idea, an affidavit wasn't even going to need to be filed until a month ago.
Right.
These communications and everything happened well before that. How is anything that they communicated in furtherance of that affidavit that they didn't even know would have to be filed one day?
it's been waived. That part's been waived because he filed the affidavit. So you can't file something that's false and then your lawyer know that it's false and then say, oh, well, privilege, my lawyer can't correct that. When he waives the privilege, and he waived the privilege. He testified about this yesterday.
Okay, Ms. Cross.
I don't think that's even close to an accurate representation of what the law in this area is. And beyond the real kind of throwing out fraud and this and crimes, which what you have, Your Honor, is a conflict in the evidence at this point. I know which way the weight of the evidence appears to me that that's going to be for the court to judge, but conflict in the evidence, that is not a crime. That is not a fraud. That is not perjury. That's a conflict in the evidence for the court to decide.
So I agree with you there that you would have to first establish a crime or fraud occurred by preponderance. Got it. And anything else?
Just that she can't, under the guise of impeachment of this witness, number one, establish that. Number two, the witness has already said he doesn't have any personal knowledge of that. And there is the kind of specificity that is required to lay the predicate for a crime fraud exception to the attorney-client privilege is nowhere close to being met here.
Okay. Anyone else want to be heard? Mr. Sadao.
Yes, Your Honor. This is what I said to the court earlier. This is not crime fraud. The scenario in the case I said, you want me to cite it for the record?
Go for it.
Okay. It's Owens Corning Fiberglass Corporation versus American Centennial Insurance Company et al. And it is at 660 Northeast 2nd, 812, out of the state of Ohio, Lucas County, Court of Common Pleas of Ohio. And it references, I'll make sure I get the right page here. Let's see. I think it's page 256. The point in the case, or the holding in the case, is if the party or witness chooses to testify falsely, and our position is that Mr. Wade testified falsely when he claimed the relationship did not begin until 2022, that if there are attorney-client communications in which the same individual witness has told his attorney something contrary to that, inconsistent with that, here that the relationship, the personal romantic relationship between Mr. Wade and Ms. Willis began prior to November 1st of 2021, which would be the day that he was hired, that if that communication took place, that is the attorney communication, that the fraud upon the court is Mr. Wade lying under oath about the starting date, and the attorney-client privilege under those circumstances where that material fact is pierced and the attorney may be forced to testify to the contrary or inconsistent statement so that the fraud on the court no longer holds. In our situation, that is precisely what we are trying to do. If this witness's testimony, and the court may have to hear some of this ex parte in camera to determine, but if this witness is able to testify that Mr. Wade told him, under whatever the circumstances may be, that the relationship with Fani Willis began before November 1st of 2021, then we know from what the witnesses testified to Mr. Wade that he lied under oath to the court, and that's a fraud upon the court, and the attorney-client communication to that specific matter is pierced and needs to go into the record. Now, how best to do that? The only the court to hear in camera, ex parte, what the communications were that are sought to be kept privileged. If the court deems that it is not inconsistent or contrary to what's testified, then you wouldn't pierce the privilege. If, on the other hand, this witness honestly, that is, now we're talking about Mr. Bradley, actually testifies to what he has told in text messages to Ms. Merchant on behalf of Mr. Rowan, that he absolutely knows that the relationship started before November 1st of 2021, then he's testifying that his client took the stand and lied under oath and therefore did a fraud upon the court. So my request is, in this regard, the court's going to have to hear from counsel, and from, that is, the counsel to Mr. Bradley, and for Mr. Bradley to determine whether or not he actually said what he said to Ms. Merchant, and whether or not it was based on communications, whenever it took place with Mr. Wood.
All right, Mr. Sato, I understand. Thank you for clarifying your argument there. So I understand this fraud upon the cart theory. And what I've been going back and forth with Ms. Merchant on earlier was that, as I understood, crime fraud applied in Georgia was that the communications had to have been in furtherance of a crime. And to me, that presupposes the existence of a crime at the time, or the forming of one at the time of the communications. The theory you're putting forward is one where we go back in time and can reopen that box because it's now become relevant for something completely, potentially unconnected to the communications whatsoever. Is that fair?
That falsity has occurred now by the very person who is attempting to use the communications as a shield to protect his lives.
Okay.
That's, and when I say crime fraud, it's a fraud waiver is what, and that's what Millich calls it, is essentially. I mean, Millich says that it doesn't offend the privilege to ask an attorney to testify to matters already freely discussed by the attorney and a client at another hearing or proceeding. Allowing a client to selectively waive and reassert the privilege as tactics dictates, suggests that the client is using the privilege as a sword and not merely a shield.
So I think it was quite explicit that Mr. Wade never waived anything regarding to communications between him and Mr. Bradley. He was willing to discuss the subject matter, but he was never willing to get into communications that occurred between him and Mr. Bradley. So as to Mr. Sadow's point of this fraud upon the court theory, my question was going to be, has it ever been applied in Georgia?
Well, the answer to that is, it's not appears to have been applied in Georgia. I cannot find a case in which it has been applied. The cases that I have, case that I gave you plus the cases cited in there, are the only thing I've been able to locate. Although I think that the bar rules, we want to go back to those, and I don't have it in front of me, that a lawyer should not allow his client to commit a fraud upon the court.
Okay.
And I think that, along with this, gives the court the discretion to do that. And the only way to make the record, even if the court suggests that this is the law that the court should apply, but even if the court disagrees, there's no way for there to be a record about it unless Your Honor does an ex parte in camera to determine the nature of the privilege, which of course Your Honor knows from earlier days is how judges can do it with the Fifth Amendment privilege. They can do it with any privilege as long as it's ex parte in camera. So what I'm asking the court to do, because when I get up, I'm going to ask you directly. I'm not going to go through this that's going on now, to find out whether or not Mr. Wade has ever told Mr. Bradley, in his capacity as his attorney or otherwise, that the relationship started earlier than what Mr. Wade testified to.
All right, understood. So the big takeaway I'm hearing from that, Mr. Sadow, is that once again, we're hearing the words a matter of first impression here. Noted. Mr. Gillen.
Yeah, very quickly, Your Honor. Number one, he apparently, that now he's claiming a privilege, which he certainly did not assert when he was communicating in text with his first.
Sure, but do we have any indication Mr. Wade waived it and allowed him to communicate by that text?
Well, we know what he did. We know what he did.
So how is that
I would
implied?
assume, and I would assume that as the attorney, that he would know whether or not he should protect a communication.
That's a pretty big assumption, right?
Not all communications are protected, number one. Number two, let's not forget how we started on this journey with the state getting up and making very serious allegations against Ms. Merchant, asking for sanctions, saying all of her representations were inaccurate. And now they are doing whatever they can to block access to that information, which shows exactly what she said was exactly the truth. What they're trying to do is they're trying to say to the court, 100% accuracy of Mr. Wade's declaration and of his testimony. And by the way, please, Judge, don't let Mr. Bradley tell you what he knows, because what he knows is that this relationship is based upon what we see from the text and what we've seen in the context, which show that the relationship started before November 2021. So I think we have a waiver issue, and parenthetically on the issue of crime fraud, Your Honor. The issue of crime fraud is whether or not in any context the communication would be not in furtherance of a crime at that time, but it could be for any particular crime committed by the client in the future as well. It doesn't have to be something that's being committed at the time. I will also note that when you look at the attorney-client privilege, the law basically says, look, this is a privilege which blocks evidence from coming in. And so in order to have that, they have the crime fraud exception, which is a very low standard once a prima facie showing has been made, which I believe has been done by Ms. Murchie.
All right, let me clarify one thing, Mr. Bradley. When you testify to personal knowledge, does that include anything you may have seen, heard, outside of communications with a client? When you say you lack personal knowledge, does that include anything they have seen or heard outside of communications with a client? And you can tell me if that question is horribly phrased. I can try again.
You try to rephrase it for me, James? I'm sorry.
Okay. When you say you lack any personal knowledge,
Yes, sir.
does that also mean that and include anything you may have seen or heard outside of communications?
Outside of communications with my client. That's correct.
Okay. And the communications that were made, if any, that relate to the subject you were asked to, were there any other third parties present that may have resulted in a waiver of privilege?
Including texts.
Am I answering your question or her
Answer my
question?
question.
Okay.
Were there any other third parties ever present with you and a client that would have resulted in a waiver of these privileges?
No, Judge. I can't recall anybody being present. I mean, we ran an office. We had people around the office, but no, I can't say that there were other people present.
All right. And did you ever receive any kind of a waiver from your client at any point?
I have not received a waiver.
And anything that you learned regarding the subject matter at all, if anything, was it in the course of legal advice, of receiving or giving legal advice?
That's a broad question, Judge, to answer, because the advice was given, and then you have interaction. I mean, it wasn't, hey, this is for, to say specifically, this was for that, or, I can't sit here and say that. So I don't know how to answer that question, Judge.
Okay. All right. So
I was given a case that may reflect the same proposition as argument from it's old case. It's Atlantic Coca-Cola Bottling Company versus Goss, G-O-S-S, 50 Georgia Appeal 637. Appears to be a 1935 decision. I've not had the benefit of jeopardizing it, so I can't say that certainly has been limited or overruled. And looks like it's in reference to maybe head note number 2, at least the one I'm looking at on the computer. And language that is in the case, okay, is As to violations of law or commission of fraud, the protection extends only to communications after the act or transaction is finished. It does not cover communications respecting proposed infractions of the law in the commission of the crime or the perpetration of the fraud. And then it cites some cases. And then it goes, the privileged communication may be a shield of defense as to crimes already committed, but it cannot be used as a sword or weapon of offense to enable persons to carry out contemplated crimes against societies, frauds, or perjuries. So our position, as I indicated before, is the witness, Mr. Wade, has committed perjury on the witness stand and called into question the statement.
All right, understood, Mr. McDougal.
Your Honor, this is adjacent Georgia law, perhaps not controlling, and I'll explain that in just a second. That's Rule of Professional Conduct 3.3A2. A lawyer shall not knowingly fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting a criminal or fraudulent act on a claim. A4, and the reason I would qualify that, since we're talking about candidate report, I need to do that. I believe this rule is regarding the conduct of advocates representing clients in court. It might not govern or control the situation where the lawyer has been put on the stand, but it's adjacent to the point Mr. Sagal made earlier.
All right, fair point. Okay, Mr. Trump, anything you want to address on that?
Briefly, Judge, and clearly there's a lot of smarts in this room, but this whole thing is a deductive fallacy. It is suggested that the truth of the conclusion of the argument necessarily follows from the truth of the premises given, when in fact the conclusion does not necessarily follow the premises. They're, called him a perjurist. He is officially succeeded in saying the thing itself is true, therefore we must ask these other questions. And Judge, it's a fallacy. It does not exist as such, and the privilege should still apply.
All right, thank you all. So I think here is what we need to do, as I understand the law. As I find it, the crime fraud exception only applies when by preponderance we found that communications made in the existence of a relationship or in furtherance of a crime, or the client at the time knew or reasonably should have known that a crime, the attorney was being used to further a crime. I don't think that's been established here. Maybe something happened afterwards, and that's something that can be argued during closings, essentially. So I don't think the crime fraud exception covers this. The objection is preserved for the record. Mr. Bradley has indicated also that anything he learned about this subject occurred during those communications. There's some uncertainty on that point, and so in order to preserve the record, at the conclusion of the hearing, I think I can go in camera with Mr. Chopra and Mr. Bradley, and we can put in a sealed filing exactly what the extent of those communications were, if any were relevant. Or excuse me, not relevant, but just what they were, and those would remain sealed until some time if we're ever directed otherwise. However, at this point, the question, getting back to the question asked by Ms. Merchant, as asked, would be sustained on the issue of privilege to premise. He may have told you something, but it does not appear that there's any evidence that the client ever waived and allowed that information to be conveyed to you. Next question.
Thank you, Judge. All right, let's see. So we talked about Ms. Willis and Mr. Wade coming to and from your office and security details following them. Do you recall that?
Do I need to look at my phone?
No.
Just asking if you
Do I recall?
Yeah.
I think I did, yes.
Do you recall security taking Ms. Willis to your office?
I'm going to object to that.
Does he recall Ms.
Actually, I
Willis
take that
taking?
back.
You can answer the question, sir.
I do recall security detail bringing Ms. Willis to my office.
Do you recall approximately when that was?
I do not.
And was that on more than one occasion?
I remember 2 occasions.
Okay.
Yes.
Can you tell me about those?
I can't remember when they were.
Were they before she became DA?
So I don't know if she had a security detail before she became DA. So, I mean, if she was sworn in, or I don't remember the dates, but I do remember. I think she was DA.
Maybe during her transition team period, was that?
No, it wasn't. Trying to remember. She would have had to have been the DA, I think. And I don't want to go on, I think, but I do remember twice her coming to our office, correct?
And she had a security team both of those times.
There was yes, she had a security team with her.
And do you believe that it's a different security team than she has now?
I don't know her security team now.
Well, let me ask,
However,
I'm sorry.
I don't know her security team now. I don't know her security team now.
Do you remember telling me that it changed at some point, her security team?
Yes, I think I recall saying that, yes.
And that the most likely people that could testify or had seen things about them having a romantic relationship early on would be the original security team.
I don't recall saying that, no, but
do you recall talking to me about other people that might have known about their romantic relationship?
I recall.
Yeah, I mean, objection based on, we don't know the source. This is either based on privileged information or it's hearsay. Neither one is.
It's neither. I asked if you recall.
You need to clarify, and if you're actually going to think, if you think that this draws on information from outside the relationship that he's already testified to, then you need to lay that foundation. That's sustained.
Are you aware of other people that you believe would have known about when their relationship began?
I object to the relevance of that. Again, the witness has testified he has no firsthand information of it. Anything he knows about the topic came from representation. Who he thinks might have been able to say something else is speculation, not relevant to anything, and a backdoor to get in the gossip and innuendo that has been pretty much this entire.
All right. Okay, Ms. Merchant, I think we're getting to the point where, you know, the reason I thought this line of questioning was appropriate was to rebut certain inferences about why we were here in the first place.
Right.
But to go into it at the granular level, I'm not as wild about. So if maybe you can ask more overarching questions, and if you have anything else you think that's relevant, then you can get to those as well.
Isn't it true that I gave you a copy of the motion to disqualify in this case? I emailed it to you and you read it, reviewed it, and emailed me back that everything in it was accurate, to your knowledge.
You emailed me, and
Objection.
Okay. All right. So there are things contained within that, Ms. Merchant, which he has now said fell within the privilege and that he did not have the ability to weigh. So I think that's where we have to leave it there.
And I believe I still have to ask the questions, and then if he wants to assert the privilege.
Well, I think we pretty much already established the privilege and the objection has been made. And I think it's a valid one at this point based on the record. So the answer was he did acknowledge that you sent him the motion, and I think we leave it at that.
Let's see. And you had knowledge about an apartment. I'm not asking what Mr. Ray told you in furtherance of legal advice, but you had knowledge about an apartment in East Point or a condo in East Point that was owned by someone, and Miss Willis was staying there.
Judge, privilege.
I think in the way the question's phrased, she qualified that, so.
I did not have knowledge.
You did not have knowledge.
I did not have personal knowledge at all. No,
So no knowledge outside of what is privileged.
that's correct.
Did you have texts between yourself, Ms. Willis, and Mr. Wade?
Do I?
Have you ever?
I have. Maybe once or twice, but
Did Mr. Wade ever ask to use your credit card to pay for trips?
Objection.
On
On privilege, I think it's still the same thing.
just asking to use your credit card, how's that in the nature of furthering a divorce proceeding?
We were talking.
I have a business card and we would use my business card. The firm would use my business card.
For travel?
Are you asking if I use my business card for travel?
Would Mr. Wade use your business card for travel?
I recall, I recall a trip, but I don't know if that trip has anything to do with this case. So I do recall him using my card once.
When was that?
I don't even know when that was, and that sounds true. I recall him using my card once, but I cannot remember what that was for. I do remember it was a trip, but I cannot actually state, where it was and who it was with or anything like that.
And he paid you back for that trip in cash?
I can't remember how he paid. I think it was. I mean, I'm not certain if it was cash or a check. We routinely would use my card for filings, for paper, for whatever stuff with the office.
But this
And
was,
so-
oh, I'm sorry. You're done, sorry.
And so he would, whether he paid me back in cash or whether he wrote a check, it was paid back to the business card.
But this was the only time he had used it for travel.
I cannot recall. I don't even have that business card anymore. But I do recall at least once for travel, yes.
And that was when you were still law partners with him, though, correct?
That is correct.
Do you recall approximately when that was?
I do not.
You did not go on that travel with him, though, correct?
I did not.
Okay. And so he asked you to use your card for the travel.
Yes, I'm assuming. We would use the card for firm stuff. And so it was a business card.
Your business card, though.
It
not
was
the-
my business card, yes.
Right.
The law office of Terrence A. Bradley, correct.
Okay. So it showed up on your accounts.
That is correct.
Okay. Wouldn't show up on his accounts, is that correct?
That would be accurate, yes.
Do you know if this was before he became special DA in this case, special prosecutor?
I cannot recall.
Did you see he and Ms. Willis together? You said you were in and out of the office, in and out of the DA's office. You saw them together, correct?
In and out of my office or the DA's office?
The DA's office.
Correct.
You saw them together in and out of the DA's office?
Did I see them in and out?
Yes.
Well, if you preface it like that, no. I saw him in and out of the office when I would be there doing my filter work for the tank team.
Okay.
He would come by. I rarely saw Miss Willis and Mr. Wade together in the DA's office.
So brought up the taint team. Let's talk about that for a minute. Tell me about, you did work as, you had a contract as a taint lawyer, correct?
That is correct.
And that was in the anti-corruption unit?
Yes, I think so. Yes, correct.
And how did you get that contract?
What do you mean, how did I get it?
How did you get the contract?
It was,
Bid? Did you apply online?
oh no, it was proposed,
By who?
we were, it was proposed by, I guess it came from the district attorney. I mean, I didn't speak directly with her.
Okay.
It was, with Mr. Wade, and he asked if we would be interested, in having a contract with the Fulton County.
Okay. He asked you, Mr. Campbell?
I think so. I mean, I can't recall if he asked us both together or not. Rarely, we all handled several, different things for the firm,
Okay.
criminal, personal injury, things like that, family law. And so rarely were we together there at the same time, like for an abundance of time. So he may have called me and then he may have called Chris. I can't recall how we got the contract, but
Did, was Mr. Wade, to your knowledge, part of the transition team for Ms. Willis?
to my knowledge, he was part of the transition team.
Did he spend a lot of time at that office during this transition period?
He did.
So from when Ms. Willis took office to when you left the firm, did Mr. Wade spend most of his time at the DA's office?
When you say most of his time, you're saying just working business hours?
Yes,
Or
working business hours.
I would say he spent, I would probably say he spent majority of time. If you say over 51%, I would say yes, he spent over 51% of his time.
And that was the entire time from when she took office to when you left the firm?
I can't say that that was the entire time, but yes, it was majority of, it was I can't pinpoint specifically when the time that he would spend. I think, if my memory serves correctly, getting to the majority of the time, it would have been, whenever he started with this, maybe.
As
That
a
was
special prosecutor?
when you say majority of the time.
Right. Okay, so let's talk about the time before he became special prosecutor. Did he spend a lot of time at the DA's office then?
He spent time. I mean, it depends on what you say is a lot. He spent time at the DA's office, correct?
And so, just so we're clear, you were hired first on January 25th. Both you and Mr. Campbell were law partners, and you were both hired by the DA January 25th, 2021. Is that correct?
Repeat the question, I'm sorry.
You and Mr. Campbell
Yes.
both were hired on a contract basis by DA Willis January 25th, 2021, correct?
Which contract are you talking about?
The first one, the taint contract, not the first appearance contract, the taint
Okay.
contract.
Well, you said the first one, and the tank contract wasn't the first contract, and so,
Okay, so what was the first contract?
to my knowledge, the first contract was the first appearance.
Okay, so let me just mark these. Let's see what I'm doing. 23, 24, 25. Judge, when they're done reviewing these contracts. Bradley, showing you the marks. That's exhibit 23, 24, and 25. You can just look at those.
Okay, I see.
So on, now that you've reviewed those, is it true that on January 25th, 2021, you got your first contract as a taint lawyer?
As a taint lawyer, yes, I see the date on that as a taint lawyer, but I'm also looking at this contract here for first appearance, and there must have been. I don't have it before me, but there must have been a contract before this.
Okay, so you think there's a fourth contract?
I can't say that there is or isn't. What I do know is that we did first appearance during COVID, and it was before 2021. So I don't know, if I had a written contract at that particular time or anything, but I do know, I think that you could look at the recordings because everything was recorded at that time as to when the first appearance contract started and the taint contract started.
So when the three of you were partners, you had at least 2 contracts to do taint work, which is filter work, and then at least 2 contracts to do first appearance work, pretty much throughout that entire 2 years, right?
Well, it renewed. So, it just renewed. So yes, if it was the same contract, but it was a renewal of.
Okay. And so how did you, and you said that you got these contracts through, Ms. Willis gave them to you, but it was through her knowing Mr. Wade, correct?
Yes. I didn't have a meeting with Ms. Willis or anything. It was brought to the attention that a contract was going to be needed or awarded, and if I was interested, because this was off of mine, and I said yes, and so
Mr. Wade brought that to your attention?
He asked if I was interested in doing the contract, correct, and then after that is when Ms. Willis, would come in, or I think we actually came down here or something, and signed the contract.
Okay. And so that is how you were paid from Fulton County, these contracts?
From Fulton County government? Yes, ma'am.
And you shared, your partnership, you shared 1/3 of all your profits with Mr. Wade?
At that time, yes.
And so his contracts, he got a contract that same year, 2021, and he shared 1/3 of all his profits with you, correct?
Yes, that should be fairly accurate.
Okay. So during 2021, 2022, you all had 2 filter taint contracts. You had 2 first appearance contracts, and you had Mr. Wade's special counsel contracts, correct?
My firm had what I have here, correct?
But Mr. Campbell and Mr. Wade were part of your firm, correct?
So I don't think at this time we had established WBC.
Okay.
At this time, I think I had mine, Chris had his, Nathan had his, and we operated in the same building. But if you asked me, did we fee share or, without everything that came in, yes, that is correct.
So you weren't actually partners, you just fee shared.
At this time, well, yes, at this time, we were not. At this time, I had Law Officer Terrence Bradley, Chris Campbell, PC, and whatever Nathan's was, if I'm not mistaken.
And all these the taint contracts and then Nathan's special counsel contracts, all of those were under the anti-corruption unit, correct?
First appearance was not under that. The taint contract, if I recall, was under the. I don't think they called it. What are you calling it?
You can take a look at your contract if you need.
Okay.
And I'm not asking about the first appearance. I'm asking about the taint contracts and then Mr. Wade's contract, which has already been admitted in evidence. If you need to look at that. Let me know when you're done reviewing.
Well, I see on the first page where it says taint attorney, and I'm trying to go through and I see where it continues says taint attorney, but it always says Fulton County District Attorney's Office. Your question was specific as to the anti-corruption unit, and I'm looking for the verbiage of anti-corruption unit, so I apologize.
Oh, no, take your time.
And see, on both pages, it starts out Fulton County District Attorney's Office, and then it just goes to initials FCDA, unless I'm overlooking where it says the anti-corruption unit, then the contract was with the FCDA. Unless you want to show me something.
I'm just asking you, and I didn't know if that would refresh your memory. Those contracts were for the anti-corruption unit, right?
Well, they were for the
Is that who you worked for?
I worked for the DA.
Okay.
I worked for the DA.
Okay, so just in general, the DA.
Correct. I worked for Fulton County District Attorney's Office as a contract person, as it says here.
And when you did the taint work, you had to report to Sonia Allen?
I did not.
You did not. Who did you report to then?
I can't remember his name. His first name was Brian.
Okay. And let's see. So I know you said you met with Ms. Willis when you signed those contracts, right?
Yes, I know I met at least one time to sign these contracts, or to sign when I signed the contracts, yes.
Did you meet with her any other times?
I did not personally meet with Ms. Willis any other time. When you say meet, what do you mean meet? What?
Talk with her, meet with her.
I would see Ms. Willis in passing if I'm walking through the office and something like that. But no, I didn't have any meetings with Ms. Willis.
Okay, so the only times you met with her were when you signed those contracts.
Clarify meet with. I
sat down and had a conversation with her.
I signed these contracts, so when I signed these, I met with her to say that I sat down and spoke with Ms. Willis, are you saying in life and you saying during this time? What are you asking me?
I mean, if it's voluminous, I can narrow down the times, but I wasn't.
Mr. Merchant, I haven't really heard a point in a while. Can we get along to something
Yes.
where we're gonna have to wrap it up?
So I had one more question about your text. Have you ever been in any group text with anybody other than, with me and somebody other than Mr. Chopra and Mr. Merchant?
You're gonna narrow that down. I'm sure I many
I can
times.
look at my phone.
No, with him, if there have been any other texts. And I think that state had some
Him-
things
him
in rebuttal they
being-
mentioned, so I was just trying to clean that up before it got there.
Try the question one more time.
Yeah. Isn't it true that the only texts that you and I have ever had have been between me and you and Mr. Chopra, or me, you, and John Merchant, correct?
Can I look at my phone?
Sure. They've said multiple times that there's this third party that we've talked to. I'm trying to establish this third party. And I don't know why it was relevant, but the state's argued it, so.
Well, if Ms. Merchant doesn't know why it's relevant, then maybe it might become relevant later, but right now.
Ms. Merchant, I think you've been able to show
Okay.
what maybe launched this and answer the state's initial claims. And so let's get back to the core of what we were here for this hearing. Do you have anything else relevant to ask?
After yes, just a few more questions. After it became known that you were placed under subpoena, did you get a call from Gabe Banks?
I did.
And was he trying to determine if you were going to be giving information in this case?
I don't know what he was trying to determine. He stated that it was an odd, I had not spoken to Gabe in a while. We are colleagues, we are friends, we are in the same fraternity, Gabe and I. And when he called, it was out of the blue. But he did call, yes, ma'am.
Okay. And you relayed that to me as well, correct?
I did.
And then you also got a call from your best friend who was relaying a message to you from Mr. Wade, correct?
No, I got a call saying that he got a call, not that a message that was supposed to be relayed to me. The call was,
I'm going to check if there's a hearsay, the response to the call for hearsay. Thus far, it hasn't, but.
Sure. So here's the objection as to the contents of the call, Ms. Merchant.
I believe the contents of the call were to remember your privilege. I took that as a threat. I think Mr. Bradley took it as a threat. And I think he would testify to that.
Well, he hasn't testified to it. He also said there wasn't any message relayed by Mr. Wade or any party.
Well, no, he didn't say it was by any
Right,
party.
Mr. Wade.
So assuming he did hear something from a party, what's the hearsay exception for that, Ms. Merchant?
I believe that it was a threat, so it's a statement against interest. I'm sorry, it's a, if he took it as a threat to influence his testimony, then it's not hearsay, that would be admissible.
All right, so.
I did not take it as a threat.
If you're saying it's to the effect on the listener, perhaps,
Yes.
then we'll go from there.
Were you told to remember your privilege?
Your Honor, the witness just testified he didn't take it as a threat.
Understood. I'll overrule the objection, the testimony given the weight it deserves.
Can you repeat the question?
Were you told to remember your privilege?
I was not.
A witness, there may be a potential witness now in the courtroom, because the person that Ms. Merchant is referring to is sitting in the courtroom.
If that witness hasn't been told to testify, then I don't see any sequestration issues.
I don't know who it is. I don't know his name.
Okay, and so were you told anything to that effect, Mr. Bradley?
Repeat the question one more time, but so I was not told, remember my privilege.
Something about privilege, remembering that.
I do recall privilege being mentioned, but it wasn't remember your privilege or, a threat of any sort.
Did you immediately call me after?
No, I called someone else after.
You called me quickly thereafter then?
I talked to you that day, yes, ma'am.
Okay, thank you.
Sit down.
Your Honor, because this is a defense witness, is it the state's first cross? Because how we had been doing it yesterday.
No, actually, we're doing it just this way.
Yeah, I've been,
Okay.
this is
I
the first time
apologize
he's gone, and then we go through all the defense, and then you'll have your chance.
Some foundation questions to begin with, please. Your testimony as you began representing Mr. Wade as his attorney on what date or what approximate date?
I didn't have an approximate date.
And give me an approximate date when you began acting as Mr. Wade's attorney.
I would say it was, if I'm speculating.
I really don't want you to speculate. I mean, you're the one that was the attorney and Mr. Wade was the client.
Correct.
So give us the ballpark figure of when it was that you began acting as his attorney.
Maybe 2017, 2018, I think, maybe.
And the purpose for which you were retained?
His divorce.
So, according to you, from that time period, your communications with Mr. Wade with regard to the divorce or any matters related to the divorce, it's your position are confidential, are privileged, correct?
Yes. Yes.
Okay, good. Now, did you ever meet with Ms. Willis and Mr. Wade prior to, and everything I'm asking you is prior to November of 2021, okay? Keep that in mind. That's.
Why are you yelling?
I don't think he's yelling, Mr. Bradley. He's just speaking up. All right, Mr. Sedal, let's go.
Thank you. Prior to Mr. Wade getting his contract with Fulton County, which was November 1st of 2021, okay? Please keep that in mind.
November 1st of 2021.
Right. Did you ever socialize with Mr. Wade and Ms. Willis prior to November 1st of 2021?
I've never socialized with Mr. Wade or Ms. Willis in any setting. If you're asking, have I ever met with them, then I would say yes. But when you say socialize, what do you mean socialize?
Have you ever gone out to eat with both of them?
Before 2021, I do not
Or
think
November 1st of 2021?
out to eat with both of them before. When was she sworn in? I'm sorry. When was she sworn in? There was a dinner before, when she was sworn in that I attended. Shaquille O'Neal was there. So it was like her inauguration dinner. So I'm thinking that's before 2021. So I would say yes.
Let's assume for purposes of my question that
Yes,
that's in early January of 2021.
Oh, that is early January 2021. So yes, it will be before November. So if it was January, yes, that dinner would have been in, I'm assuming January.
Okay. And any other time that you socialized, went out to eat, went to anyone's home, you know what socialized is?
Exactly. So no, I did not socialize with Mr. Willis. With Miss Willis and Mr. Wade.
So prior to November 1st of 2021, did Miss Willis come to your offices? Your offices, the offices that you shared with Mr. Wade.
I think she came once or twice to our office, correct?
And the purpose for which she came?
I don't know. We had separate offices. I do recall
Well, let's,
I do recall some type of meeting happening at our office, and I don't know what that was about. I wasn't a part of those meetings. There was a meeting, there were other people there. There were other people from the, I want to say DA's office there, maybe.
okay, let's go back to the basics. Ms. Willis came to your offices, together offices, on a couple different occasions.
I recall Ms. Willis coming to my office at least twice.
And on at least one of those occasions, or you tell us, did Ms. Willis meet privately with Mr. Wade in his office that you observed or heard?
I can't recall.
You can't recall?
No.
Did she ever meet with you in your office? Ms. Willis now?
Privately in my office? No. I've never met privately in any office with her outside of signing this contract.
Did Mr. Wade, prior to November 1st of 2021, ever talk to you about socializing with Ms. Willis?
I can't recall.
You can't recall?
You're asking me if he ever mentioned to me that he socialized.
With Ms. Willis, correct.
And I'm saying I cannot recall if he socialized with Ms. Willis, if he ever mentioned to me that he socialized.
Did he ever mention to you that he ate or went out to dinner with Ms. Willis? Again, time period before November 1st of 2021.
Did he, repeat your question?
Did Mr. Wade ever tell you prior to November 1st of 2021 that he had socialized, gone out to eat, visited Ms. Willis in anything other than a professional setting?
I'm sure he did, maybe. I don't recall any specifics of any dinners, any specific places. It's been 3 years ago, the time frame, but I do not recall at this time whether or not he ever mentioned any dinners or socializing.
Did Mr. Wade mention to you that he visited Miss Willis at Miss Willis's then current abode, which would have been a place, not her original house, but a place she was staying in the period of 2021 before November 1 of 2021? And his question is, did Mr. Wade ever tell you that he visited Miss Willis at her house?
I don't think I can answer that.
Yeah, privilege based on communication with my client, also based on hearsay.
Mr. Sidak, if you want to try and rephrase the question, you can, but otherwise that would be sustained.
On both grounds or just on the privilege ground?
Just, oh, I didn't hear a second ground. What
The hearsay ground.
Oh, that would be on privilege alone.
Did you talk to Mr. Wade at all about his relationship with Miss Willis prior to November 1st of 2021?
I think he's just laying a record, Mr. Wade. It's okay. And so on the same grounds, Mr. Sadal, on all subsequent grounds, apparently the relationship with Miss Willis in any way is covered by privilege according to this witness.
Well, I think the key words, respectfully, Your Honor, are according to this witness. So I'm trying to drill down to see if there are communications that are not within the privilege.
Sure.
I can.
So then we need to acknowledge the privilege in the form of your question, right?
You're asking me to ask it as in a way saying, are there any non-privileged?
Essentially.
Okay. Did you ever communicate with Mr. Wade prior to November 1st of 2021 about Miss Willis that was not privileged?
I mean, we discussed this contract.
But
This contract doesn't help. You have to give me a exhibit number, please.
you said before November 2021?
Yeah, November 1st of 2021.
Before November, this contract for 1/25/21 is before that. So I mean, we discussed this contract.
Okay. And if I remember correctly, again, just give me that exhibit number so we can reference it.
Exhibit 23.
Okay, hold on 1 second. 1 second. On exhibit 23, did I understand you to say that it was Mr. Wade that effect brought you and Ms. Willis together for the contract?
That would be accurate, yes.
Okay. And what did you understand was the relationship at that point between Ms. Willis and Mr. Wade, for Mr. Wade to be able to bring you to Ms. Willis for the contract? It's not a hard question.
I'm just, say that again.
Mr. Wade is the one that basically says to you, go see Ms. Willis about this contract, right?
Mm-hmm.
Okay. That's a yes, correct?
Yeah. Yes.
So Mr. Wade had to have some knowledge, you would assume.
Yes.
Right? That you going to Ms. Willis might bring you the contract.
I never went to Ms. Willis. So I stated I never went to Ms. Willis. I was told about that there was a potential contract, and I was asked by Mr. Wade if I would be interested in doing that contract.
And my question to you is, what was the basis that you understood Mr. Wade being able to essentially offer you that contract on Ms. Willis's behalf?
I'm going to object to that. That's a mischaracterization. Mr. Wade offered it to him. I think he said he expressed interest. And also, I don't see the relevance of this at all.
So just in terms of relevance or phrasing, I'll overrule on those grounds. So the question is standing unobjected to, Mr. Bradley.
Can you repeat the question?
You've explained to us how the contract
Yes.
came to you, correct?
Yes.
And my question is, what was your understanding of the relationship of Mr. Wade and Ms. Willis for it to have been offered, or whatever word you want to use, for him to have said, expressed to you whether you had an interest in the contract?
Privilege.
All right, Mr. Evans is involved privilege in my question, so Mr. Sadell, I think you need to clarify whether.
Was it a privileged conversation that you had with Mr. Wade that let you know about the contract?
Or, no, it was the relationship was the question you're focused on.
Is the nature, I'm trying to do it in such a way, and I understand what the court said. Was the relationship that I asked you about just now between Mr. Wade and Ms. Willis that gave rise to the contract? Did you know about that relationship as a result of an attorney-client communication?
No, I knew of that through whatever work they did together as municipal court judges.
And how did you know that? Who told you about the work that they did together as municipal court judges?
Mr. Wade told me that they did work at some conference.
Okay, now, this would have been something that Mr. Wade said, according to your time period, at the time that you were representing Mr. Wade, correct?
Say that again, SLE?
Mr. Wade would have told you what you just told the court after you had established an attorney-client relationship with Mr. Wade, correct?
Yes, but when he told me of them being at a conference, I mean, I'm not understanding how relate. I'm trying to understand your question.
Well, my question is basically, you had communications with Mr. Wade directly that
Yes.
were not attorney-client privilege, right?
I've had conversations with Mr. Wade that were not attorney-client privilege, yes.
That involved Ms. Willis, correct?
I just stated that they were at a conference. I don't know whether or not that involved her or not.
Well, if he's talking about her, that is
if Mr. Wade is telling you about Miss Willis and Mr. Wade having met at a conference, right? Then he's talking about Miss Willis, correct?
Yes, but he also told me about other people that he met at the conference.
But he told you about Miss Willis as well, correct?
I think so, yes.
Okay, so there were communications in which Miss Willis was at least a topic that was not covered by attorney-client privilege, correct?
This particular instance, I was told about a conference. And
when were you told this?
I can't remember the dates of the conference, but it would have been after the conference.
Okay, well, I'm trying to get just the time period here. After the conference, I want you to understand from the record, I believe we've shown that the conference was sometime in October of 2019. Okay? So could you give us an idea, that being a fact, when you would have had this communication about meeting with Miss Willis at the conference, that is Mr. Wade meeting Miss Willis at the conference?
If that's the conference that they were at, yes, then, I don't know how many municipal court conferences there are. I do know that at the time that I was in the firm, Mr. Wade was, he had some position with the municipal court.
Yeah, right now, my only question is time-wise, assuming it's October of 2019, when do you tend to remember? What's your best recollection of when Mr. Wade told you about?
I can't remember because I didn't even remember that it was October 2019 until you said that.
Okay. So you don't have a present recollection?
I do not remember that, no.
Had to be before the contract, though, in January of 2021, correct?
That they met?
No, that you were told about Mr. Wade and Miss Willis meeting at the conference had to be before.
Oh, yeah,
right?
Yes, it would have been before that, yes.
So what other communications did you have with Mr. Wade about Miss Willis that are not privileged? We know of one, about the meeting at the conference. Are you suggesting that that's the only one you ever had about Miss Willis that isn't?
I cannot recall any. I cannot recall.
You cannot recall whether there were any other communications that weren't privileged?
No.
I'll be specific, and I understand there's probably going to be objections, but I want the record to reflect. Did you have a conversation with Mr. Wade prior to November 1st of 2021 about Mr. Wade dating Miss Willis?
Mr. Wade has risen. An objection is sustained for the record. Excuse me, Mr. Evans.
Say that again.
You don't have to answer the question, Mr. Brown. Next question, Mr. State.
Well, I understand it's been objected to and the court has sustained the objection. Can you tell us the circumstances in which, that is, under which Mr. Wade may have told you about dating? What I want to do is try to figure out if we can, you tell me if you want me, if I can do this. I'd like to know how the communications themselves took place, where they took place, how they took place, under what circumstance, whether he was at the time providing advice, seeking advice. So those are the basics. If I can ask you as to all those, but if the court's going to sustain the objection to those, then I don't want to waste your time.
And that's something I'll cover in camera. So I'll note the question and your question for the record, and I'll sustain the privilege objection to that.
Okay, all of this prior to November 1st, 2021. Okay? I'm going to show you two text messages. I don't have hard copy.
Text message?
This is
Like that one.
That data, see, what do you
These are text messages.
And you want to get into the content?
I'm going to set up a question based on this. Here's the thought.
Okay, so I'm gonna have objections.
Of course, you're gonna have objections. I realize that. I want to be able to show it to him, and then I'm gonna frame the appropriate question, and then you're gonna object. We'll see where we are. May I approach?
You guys.
Look at this text message. Of course. Kind of hard to object, I haven't asked a question. And I know it's not. Then you must be a soothsayer. Mr. Bradley, I showed you two text messages, correct? Both of those text messages occurred on January the 5th of 2024 at approximately 11:56 a.m. Am I correct?
I think, yes.
Okay. And the text messages would have been between you and Ms. Merchant, correct?
I didn't see it. Yes, it should be.
Okay. And I've shown the same two to prosecution, so we're talking about the same two. In the text message to Ms. Merchant, you indicated knowledge of some activity on the part of Mr. Wade, correct?
I'm gonna
I haven't asked him anything about what the,
flag for the court that this is a topic and a specific exchange that Ms. Merchant went into, and there were objections that were sustained.
Understood.
yes. And it's your testimony that the information that you imparted to Ms. Merchant in these two text messages is based entirely on confidential communications between you and Mr. Wade, correct?
An objection. He's referencing specific knowledge. The specific knowledge comes from Mr. Wade, which is regarding established privilege.
What other question? He didn't get into anything. He just said, are these two text messages about privileged communications? We haven't actually, he's testing. I don't see an issue there.
Yes.
And is it your testimony that the knowledge that you have, which you imparted in these two text messages, came from Mr. Wade and Mr. Wade alone?
Yes.
Is that correct?
Yes.
Can you tell us when it was that Mr. Wade imparted this information to you?
Objection.
All right. And I think
that's what you're going to do.
Sure. So I'll sustain that on privilege.
And I'm going to introduce for the record when we finish these two text messages so that Your Honor has those back there so that you can.
Sure. What would they be marked as?
Here you go.
I have a whole set.
Okay.
Go ahead. Once I put a staple in it, I think it'll be Defense Exhibit 26. Here, give me a real pen.
All right, so this is marked and on the record is Defense Exhibit 26, but not necessarily for its.
This is not admitted
Evidentiary value.
26. This is for purposes of the court conducting the in-camera review. And put a staple in it if you make sure that you see it. No charge?
Nope, it's free.
All right, let's say that. What else?
All right, so there was also reference, if I remember correctly, to some email correspondence in which Ms. Merchant sent you the motion that she was going to file to disqualify
Ms. Willis and Mr. Wade for your review. Is that correct?
That's correct.
Okay. And that was sent to you in an email?
That was correct.
And did you respond to it in an email?
I don't think I responded to her in email.
Actually, you
Responded by text.
responded by text. I'm sorry, I mischaracterized it. You responded by text?
If I can look at my text, I can, but I'm assuming I did, but.
Okay, I'm gonna get it for you, because I don't want there to be any assumption. As long as we have it. Let me show you, this is. Here. I don't have anything besides just damage.
So, is that what you?
I'm going to show you if I might approach. I made reference to an email Ms. Merchant would have sent you about the motion she was going to file. If you look at this, does this appear to be the email that you received? It's dated January the 6th, 2024, at 10:20, 10:25 a.m.
Yeah, I see it, the email, yes.
So that's the email that you received, correct? Along with, obviously, the attachment, which is referenced.
Yes.
And then, did you respond to that email within the text message that I just placed before you?
Yes, I said looks good.
So the answer is yes.
Oh, yes, I did.
Okay. Then we'll mark this as another exhibit for your honor to look at. Since you love my tone, can I have some? Oh, I'm sorry, I didn't catch that. Somebody like. Okay, I'm going to have these marked as 27. Okay? All right, so is it your position that what is reflected, let me hand it to you. Yeah. What's the course rule, to ask or not?
I will take it case by case. I think he's doing all right, so let me ask for this witness.
Is it your position that your response, which is the second page of Defense Exhibit 27, is based on a confidential or confidential communications that you had with Mr. Wade?
Do you want me to read the response?
No, I'm only asking you whether or not the response, you actually already said what it said. I don't want you to read it again. Is that response, based on confidential communications that you had with Mr. Wade?
Objection, this is privileged and you know that.
All right, so now we're talking about the email, essentially referencing the motion as a whole. He hasn't been asked to actually confirm or deny any specifics, just to say whether his response is privileged. So I think we're just laying the foundation, just like we did with the text message. So you can answer that question, sir.
Was my response privileged?
Was your response to the email of Ms. Merchant, which is on page 1 of that exhibit, is your response, which is on page 2, is that based on knowledge that you received from Mr. Wade pursuant to confidential communications?
Yes.
Have you discussed with the district attorney's office this case or your purported testimony?
Of my testimony?
Yes.
No.
At all?
No.
No prep, no conversations, no nothing?
No.
Have you given your attorneys for this matter, did you give him permission to speak with the district attorney's office?
Well, he can assert his own privilege, but that's kind of crazy.
Is there a objection to be heard?
Absolutely, this is
Okay,
perfect.
sustained. Stay down. Next question.
Do you know whether or not your attorney shared privileged information with the district attorney's office?
No, I don't know what my attorney shared or didn't share. I don't know if they even met.
Last question. Have you spoken to Mr. Wade prior to today? No, actually, withdraw that. You're no longer in the same partnership or fee sharing arrangement with Mr. Wade, correct?
That's correct.
When did you leave that fee sharing partnership, pseudo partnership arrangement?
I don't remember the hard date, but maybe sometime like July, August of 2022, I think.
Okay. And what was the reason for the partnership or the fee sharing arrangements? What caused the separation?
I wanted to leave and go out on my own.
And that's the only reason.
I wanted to leave and go out on my own, yes.
I understand, but that was the only reason. There wasn't any suggestions or allegations of any form of misconduct on either part, either on your part or Mr. Wade's part, correct?
Misconduct of what?
I'm trying not to get into the specifics. Was there any allegations made of suspected misconduct on your part or on Mr. Wade's part? That's a fairly simple question. Did he accuse you of doing anything? Did you accuse him of doing anything? Without getting into what it is, were there any accusations made by you or him against each other?
We had a disagreement, yes.
And had that disagreement have anything to do with Miss Willis?
Oh, no.
Okay. Did it have anything to do with your conduct?
No.
Did it have
Wait.
anything to do with his conduct?
Hold on, wait. So we had a disagreement. Whether the disagreement was, we disagreed. And so we dissolved, I left the firm.
All right. And was the disagreement having anything to do with alleged or supposed misconduct by either one of you?
If you define misconduct, I'm telling you, we had a disagreement and
Just tell me what the disagreement was.
The disagreement is mine to know. I mean, I don't see the relevance of the disagreement that I had. It had nothing to do with this Trump case or any other case.
I'm simply getting a question asked, what was the disagreement? It's not privileged, correct?
No, that is privileged.
Oh, it is privileged. Why is that privileged?
Because it's privileged. I can tell the court in camera, but it was privileged.
Ask a few questions further to see if this is actually something that does fall within that privilege. We can take it from there.
Did it have anything to do with you representing Mr. Wade in any capacity? Excuse me.
It would fall in that line, yes.
But your testimony is that it has nothing to do with your representation of Mr. Wade in connection with Miss Willis.
As a connection to Miss Willis, that's correct.
It's connected to the matter for which you were hired by Mr. Wade?
I wasn't hired by Mr. Wade.
I thought you were the attorney representing him in the divorce.
Oh, I apologize. I thought you were saying something else. Oh, yes. So will it apply as to whether I was hired during the divorce? Yes, that's correct.
I'm not sure what this correct means under that. You kind of got lost on it.
Yes, the
It
question.
did or did not relate to your representation.
It did relate to my representation.
In the marriage case.
It does.
And this was whose decision was it? At that point, did you stop representing Mr. Wade?
It wasn't at that point, no.
Was it before that?
No, it was after that.
Okay. And how much longer did you represent Mr. Wade in the divorce action?
I like to see the divorce proceeding to see Mr. Wade. I represented Mr. Wade for a time after that. He represented me in a construction case for a time after that. And I'll have to look at the filings. I ended up hiring new counsel for my construction case. He ended up, but it wasn't right at that moment. It wasn't in a matter of weeks. It was.
So you continued representing him in connection with the divorce case after you had the separation that you've made reference to?
And he continued to, yes, and he continued to represent me on a construction case.
But the separation, at least in part, if I heard you correctly, and please tell me if I'm wrong, had something to do with your representation of him in the divorce case.
That is correct.
Now, Mr. Wade has testified that he did not have a relationship, a personal relationship, a romantic relationship with Miss Willis until sometime early 2022. Okay? I'm leaving that as the premise of what I'm about to ask you. Do you possess information that counters that, that's inconsistent with that?
Any information Mr. Bradley has would be privileged, Your Honor.
Okay, let's say no. I think we.
Would such information be privileged in your mind?
I think this has already been asked during Ms. Merchant's direct, so we're covering the same ground. So I'll sustain that.
So I can't get an answer to whether he possesses information which is inconsistent without getting into the information itself.
I think the issue would be we've already gotten an answer on that. Now we're asking the same question again. Ms. Merchant asked a variation of that, and he already answered.
I think the variation, Your Honor, was referencing whether or not he had what would be personal information, independent source information. Mine is not so limited. Mine is, I'm asking him point blank whether or not he has information from whatever source, including Mr. Wade, that is inconsistent with Mr. Wade's testimony.
Because if it includes Mr. Wade, it is privileged communication. So therefore, the answer is it's privileged. If it excluded Mr. Wade, that would be a different appropriate question.
And I just want to say, the answer is either it came from privileged information or it's hearsay. That's it. He's already testified he has no personal knowledge.
Unless it's for impeachment at this point. But Mr. Seda, I think that might be too fine a distinction for me to see the need for the question. I think I'm failing to see the difference.
Well, I'm not asking respectfully, I'm not asking you to see the difference. I'm asking whether I can ask that question and elicit a response which doesn't elicit the actual communications, which is what I'm attempting to do. And if Your Honor says I can't, then I'm finished.
And I think that this was another aspect of what came up before, which is in my mind, even confirming the existence of the information goes into privileged communications, whether he does or does not possess information. If it came from that relationship, that's part of the privilege as well. So if I make that clear, then
So you're sustaining what the objection would be.
That's right. It'd be sustained on privilege.
And of course, all the questions that we're
Reserved for the
talking
record.
about as far as the foundation about when things are said and what is said, you're going to go into, if I understood correctly, ex parte in camera with the two exhibits we talked about.
That's right. My intent would be to make a record of the knowledge of when it was attained and the extent of it in the different sources, and that'll be sealed.
And what was actually said.
That's right.
So I guess my question before I sit down is, if hypothetically you learn through this in-camera ex parte examination that the information that this gentleman has through the attorney-client privilege is in fact inconsistent with what Mr. Wade testified to under oath, then the court is going to then make a determination of whether it can be used here or whether it just remains in the record sealed.
So my intent would be to make the distinction of, from the in-camera hearing, if I still determine that everything is covered by privilege, then anything else that is said cannot go into the factual determinations or credible determinations that need to be made. And so just the issue of whether the privilege did or did not exist is preserved.
So again, just to follow through to make sure. So if the court knows that there's been a fraud upon the court through the lie of Mr. Wade, none of us are going to know that that in fact occurred, and the court's going to be in a position of making a determination on the motion, even though the court knows that it doesn't have all the information, truthful information.
I'll take a closer look at the case law you provided to see if that is actually a variation of the crime fraud exception. And I'll apply the crime fraud exception as I see it.
Right. And again, I'm not suggesting it is a variation. It is totally separate from crime fraud. It has nothing to do with using the legal advice of the attorney in order to commit a crime. It's you go ahead and commit fraud or lie to the court when you fully know that someone, your attorney, has information which is counter or inconsistent with what you've testified to.
And to that end, Mr. Sadat, that is something that you can, I mean, I've got this case from Ohio, but if you can find something more on point from Georgia before we schedule
Other
this
than the
for
one I gave you,
the
1935 case.
The Atlanta Bottling Company. I don't think it went that far. I think it just kind of said the sword and shield language, and it didn't go so far as to say there's this alternative theory about fraud upon the court. But we can flesh that out in our research.
I appreciate that. Thank
you. Mr. Stockton.
No question, Judge.
Mr. Durham.
No question, Your Honor.
Mr. McDougald.
No question, Your Honor.
Mr. Rice.
I have a few questions, Your Honor.
Mr. Bradley, you were counsel for Mr. Wade in the divorce case when the interrogatories were initially served on opposing counsel on or about December 27th of 2021, correct?
That's correct.
And you were also counsel for him when the amended interrogatories were served on May 30th of 2023, correct?
That's incorrect.
So you ceased representing him sometime before May 30th of 2023.
That's correct.
At any point during the divorce proceedings, was a pleading filed with the court or a paper served on opposing counsel that purported to have your signature that you were not the one that signed or authorized your signature on it?
Say that again?
Did anyone sign your signature without your authorization on any pleading or any other paperwork served on opposing counsel in the divorce proceeding?
I don't think so. If you have the documents, I can authenticate my signature.
And you have testified that you also practice criminal law and divorce law and perhaps other types of law as well?
That's correct.
And are you aware that OCG 16-6-19 defines adultery as a misdemeanor crime in the state of Georgia?
If you say so, yes, sir. Go ahead.
Okay. Judge, I would ask the court to take judicial notice of that.
For what relevance?
Judge, I think it does go directly to the crime fraud exception. Because before we draw objection, because if Mr. Wade was providing information to his counsel about his intent to either commit adultery or that he was committing adultery, then that would be a misdemeanor crime. It would implicate the crime fraud exception. And additionally, as we know from yesterday's evidence,
Isn't adultery as a statute just on its face been found unconstitutional? You can't actually charge anyone with adultery anymore.
It is still current.
Then it can't be a crime.
It's still a current charge.
Let's move on to that next argument.
Additionally, Judge, with regard to the interrogatories, we have 3 different sets of interrogatories that were filed that came into evidence yesterday, 21, May of 23, December of 23, that contain false information. We also have the January of 24 that contains the invocation of privilege. So to the extent that this witness has information, both with the original interrogatories that were filed in December of 2021, and frankly, with regard to the later ones, even though he wasn't counsel, that would be a false swearing and fraud on the court, which again is a criminal offense And therefore the crime fraud exception would apply as well.
Okay. Understood.
No further questions.
Okay, Mr. Gillen.
Good afternoon, Ms. Bradley.
Good afternoon.
Been a long day. When did you sign your engagement letter with Mr. Wade to represent him in divorce proceedings?
It would have to be 2017, 2018. Same time frame, 2017, 2018.
So did you sign or have signed an engagement letter to represent him, or are you just speculating?
I can't recall. I mean, we were in a, we shared space. I can't recall if there was a contract or if there is a contract. I think there is a contract, but right now it'll be speculation.
Right now, sitting here, you do not know whether or not you had a signed engagement letter with Mr. Wade discussing the parameters of your legal representation of him. Isn't that correct?
That's not correct. I mean, I can't say I don't have my files or anything with me.
Well, sitting here, you do not have specific recollection or knowledge that you even had an engagement letter to represent him. Isn't that right?
I think I had an engagement letter, but I do not know specifically if I had an engagement letter.
Well, when did you open a file? Did you open when you represent someone, you open a file in your office? And when did you open the file on Mr. Wade?
I am going to object to the relevance of this line of questioning. There has been no dispute by the attorney or the client that there was an attorney-client relationship. And so I object to the relevance of the circumstances under which that engagement began, because as Mr. Gillen knows, that's not a factor in determining whether there was a true attorney-client relationship.
Well, Your Honor, it's not just up to Mr. Wade and Mr. Bradley, it's up to the court.
I agree with you there, Mr. Gillen, and so I'll give you a little bit of leeway, but I don't think we can spend too much time on this.
No,
so
okay,
we'll see.
Your Honor. Now, did you or did you not open a file in your law practice with Mr. Wade's name on it? Yes or no?
Yes, I had a file with Mr. Wade's name on it.
When did you open that file?
I'm assuming 2017, 2018. I can't tell you the exact date. I've said that 3 or 4 times.
Well, let's approach it from another angle. When is the first invoice that you sent to Mr. Wade for your legal representation?
I didn't send him an invoice in that capacity.
So what we have here is you're not knowing whether you even have an engagement letter. You don't know whether you actually even billed him, correct?
I represented Mr. Wade. I signed the documents that we filed. I filed the documents. There's depositions that I had with the divorce attorney that was representing his wife.
I'm sorry, sir, that's not my question.
Okay.
My question is, did you bill him in your capacity as the lawyer that you're telling him?
I don't recall.
As a matter of fact, did you have any invoices where you billed him on an hourly basis?
I don't recall.
And the answer really is no, isn't it, sir?
I don't recall.
And the reason why it's no, isn't it, is because what happened is that you and Mr. Wade were in a law practice together, and it was a very small work environment, correct?
It was a work environment, yes.
A work environment where you and him would meet and talk literally every day, correct?
Not every day, no.
Well, almost every day.
Not almost every day. I stated earlier that I ran one side of the practice. Mr. Wade did, and we rarely were there at the same time. I stated that earlier today.
So, well, just give us totally how much money you got for representing Mr. Wade in this, since 2017 or whenever you told us, up until you dropped off the case in 2023?
I don't recall.
Would the answer be zero?
I do not recall.
Well, you would know whether you got paid or not, wouldn't you, sir?
I do not recall.
So you don't recall whether you as an attorney got a single dollar to represent Mr. Wade, correct?
That's correct.
Because you really did it as a friend, didn't you?
No, I did it as an attorney.
Well, an attorney that wasn't being paid. You were doing it pro bono for a friend, weren't you?
I'm going to ask and answer.
All right. So I'm just saying that, Mr. Gillen, I think the law is clear that money doesn't even have to change hands for that relationship. I'm making a finding based on the evidence that's already been presented, and with the fact that he signed pleadings to the depositions on Mr. Wade's behalf, that attorney-client relationship did exist.
Well, at some point, I was just laying the foundation of the circumstances in terms of the non-billing from the 2017 period and whether there was really an attorney-client privilege there. That's what I was trying to do.
Okay. If the dispute is just when it occurred, you can try to hone in on that, but the questions I've heard so far are more from you were never paid ever, it was from an overall angle.
Well, from 2017 until November of 2021, you didn't receive a dollar from Mr. Wade for your supposed or your representation of him, correct?
I don't have the file in front of me and I do not recall.
Okay. And the reality of it is, as I mentioned or asked you a few minutes ago, is that it was a small firm and you were doing him as essentially a favor as a friend and as a law partner, correct?
No, I was representing him as an attorney. Were we in the practice together? Yes. And were we, or are we friends? I mean, we were friends at the time, yes.
Well, you were friends and law partners, correct?
Yes.
And in a small firm, and I know because I'm in a small firm, people will sit around the office and talk about their social life and what they're doing, correct? Correct?
If that happens in your small firm, yes, yes.
Well, that doesn't happen, or did it happen in your small firm?
The witness has been asked very specific questions about conversations about socialization, and we've gone on through it, so I think this is asking actually.
All right, I'll answer this one question overruled.
Repeat the question.
Well, did you in your small firm have occasion to where people would sit around and socialize and talk about what was going on in their lives as opposed to merely talking about the law?
Yes.
And you had those conversations with Mr. Wade as a friend on a social basis, didn't you?
Objection, going back into the privileged communication.
Not yet, but it might.
I assume, yes, we talked about sports. We talked about, sports a whole lot.
You talked about life, about what was going on in your life and what was going on in his life, right? Right?
Sometimes, very rarely, yes, sometimes.
And that is what you do in a small work environment when you know people very well and you do favors for them, correct?
Again, I'm going to object.
Yeah.
Questions?
All right. So say next question, Mr. Gill.
Now, in that capacity, didn't you have discussions with Mr. Wade about what was going on in his social life that had nothing to do with him asking you legal advice?
Objection, to be more specific.
I think he's just asked whether he socializes outside of legal advice. So he can answer that question.
I did answer the question. I said we talked about sports a lot.
And I'm asking, sports is one thing. The social life, did you talk about each other's social life, like Mr. Wade, and who he was dating?
All right. So that'll be sustained on privilege.
Okay, Your Honor, just for the record, I would state that my objection would be that the privilege only protects communications in furtherance of seeking out a legal advice, not talking about something that might be personal or confidential. And that's the distinction that I would draw.
I think that's an accurate legal point. However, I think the witness has already been questioned and testified on this point. So, next question.
Now, you got into the fact that you were the initial attorney on the divorce case, correct?
That is correct.
Now, did you and Mr. Wade, without getting into discussions, did you and Mr. Wade together to prepare his responses to the interrogatories which were filed initially in the divorce case?
I'm assuming we,
Objection. He's asking about interrogatory responses, preparation of the case in the divorce case. I mean, that's all covered under attorney-client law.
Mr. Gallo?
Well, I don't think it's attorney-client. Did they meet together? And when the interrogatory answers were filed, did he file them? And did he do that in concert with his client? There's nothing privileged there.
Did they meet and work together, and that work taking the form of them talking back and forth to each other on the right responses?
I'll change a little bit. Did you review yourself the interrogatory responses given in the divorce case?
I did.
And whatever knowledge that you had when you were involved in the interrogatory responses, you had the knowledge of all that material or information that you had without getting into the content.
Objection.
You had all of that knowledge and information. I'm sorry, let me get my question out
That's what I
before
was trying to
he
say.
objects. And when you filed those interrogatories, you had all the knowledge and information that you had obtained from Mr. Wade from 2017 up until the date the interrogatories were filed, didn't you, sir?
Okay, so that's, the follow-up question to that is going to be incorporating knowledge learned during communications.
No, I'm not going to have a follow-up question. I just want to know whether is that the case? When he filed the interrogatory forms, he had all of the information that he had discussed with Mr. Wade from 2017 up until the time. That's it. That's my final question.
Okay,
It's all
in which case, without doing that extra assuming link that he based his answers on those communications, it has no relevance.
Well, it does in the sense that it shows what knowledge he may have had when he, the attorney, is filing interrogatory responses. That's what it shows.
Okay, I'm still not saying the relevance of his knowledge is the attorney filing the responses, unless you're linking this back to
Well,
Mr. Wade.
it gets back, Your Honor, to whether or not, if you're an attorney and you're filing an interrogatory response, which you have reason to believe, or specific information to know that certain responses are not accurate, then you shouldn't be filing them. And now, so that's where I was going with that. So if he's got a body of knowledge over here that's built up from his communications with Mr. Wade that everyone so dearly doesn't want everyone to know about, in spite of the allegations made against Ms. Merchant. Now,
So what if the question was, did you, when you signed your name to the interrogatories, did you commit any knowing fraudulent statement and submitting those to the court at the time? Would there be a problem with that statement or that question?
well, I mean, I think that is a conclusion that others could draw, like the court. I just want to know that he had all that information at the time that he, as the attorney, filed the interrogatories. That's it.
We would object. This does fall under attorney-client, and he is making presumptions about when information may have or not have been disseminated to Mr. Bradley in his capacity as attorney. He didn't have to know about anything at the time of, in the middle of, at the end of, or he may never have had that information. There's too much presumption associated with it. The whole matter is covered on his privilege.
One comment on that, Your Honor. We have spent almost a day talking about trying to block public the dissemination of what Mr. Wade said, either as an attorney or in any capacity, about his relationship with Ms. Willis prior to November the 1st, 2021. And questions about discussions in 2019, all objected to, the claiming the privilege. And now to say, well, that doesn't mean that he learned something after. I'm talking about, what did you know at the time the interrogatories were filed? And everything that now they're claiming privilege, well, that's fine. The court will address that in chamber and in due course. What did you know?
I'm sorry, Mr. Gillen, I really don't see the distinction. So your question's noted for the record and your objection as well.
All right, and I'll follow up with this. Now, you're leaving removing yourself from the case, the divorce case, correct? You withdrew from the divorce case, correct?
Correct.
Did you do that as a result of your concern about any of the accuracies or representations which had been made by your client in the divorce case?
No.
Objection.
Okay, so that's going to cover communications during the relationship?
Well, Your Honor, hypothetically, not saying this is the case, hypothetically, if Mr. Bradley, knowing, let's say hypothetically, that he speaking with Mr. Wade, was aware that the intimate or personal relationship, romantic relationship existed prior to November the 1st, 2021, and started in 2019 or 2020, if he's armed with that information that he's obtained from Mr. Wade, but Mr. Wade would want to insist on responding to interrogatories which were contrary to the information that Mr. Bradley would have, then I'm asking him whether he took steps as an attorney to say, I cannot be a part of that or countenance that, therefore I'm withdrawing from the case.
Sure. I still see that as covering their communications. So I'll sustain that objection.
All right, thank you, Your Honor. That's all I have.
Thank you, Mr. Gill.
Thank you.
Mr. Kucherov, are you still with us? Anyone on behalf of Mr. Floyd still joining us? All right, moving on, Mr. Cromwell.
Just two brief questions, Your Honor. I think everybody's exhausted with this line of question, right?
Go, Mr. Bradley. When did you withdraw from Mr. Wade's divorce case?
I don't have it in front of me. I don't have the file.
Was it sometime in 2023?
No, agree. See, I left in 2022. It could have been anywhere between July of 2022 and maybe December of, it wasn't, I don't have the accurate date, but it wasn't when I left, and it wasn't.
I'll make it easier.
Okay, all right.
You were not his divorce lawyer at the time the interrogatory responses were filed in May of 2023. Is that
Oh, no, I was not. Okay, yes.
And as of today's date, Mr. Wade is still a married man. Would you agree?
I haven't kept up with the divorce proceedings, but I think they're still open.
Okay, so, and if they're still open, that means he's still a married man.
Yes, that's correct.
So if the fact that in a pleading, there's a reference to the marriage is irretrievably broken, that doesn't mean the marriage ends, does it?
But I guess you have to ask the judge that's handling the case.
Well, it doesn't end until there's actually a divorce decree signed by a judge. Would you agree?
I would agree.
All right, thank you.
Okay, Ms. Cross, were you taking?
I am, Your Honor, and I'm going to have a minute. My cross-examination might be a long one. So we can go for an hour and a half. I have just a 5-minute break.
Sure. All right, we'll be back in 5. Ms. Cross.
Thank you, Your Honor. Mr. Bradley, have you still got the exhibits 23, 24, 25 there in front of you?
I do.
And 23, that's one of the contracts for your personal LLC, your PC, your personal legal entity, right? For the
That is
district
correct.
attorney's office? Yes?
Yes, that's correct.
Okay. And I understood your testimony to be that any income that came into the partnership, when I say partnership, let me be more specific. You had an individual legal entity. Mr. Campbell had an individual legal entity. Mr. Wade had an individual legal entity. But y'all had a partnership agreement, right?
Yes, but we didn't have that, the entire time.
There was
Yes.
a period of time that we've been talking, or that we had talked about in 2022, prior to leaving the firm, that there was an actual entity for the three of you, correct?
That is correct.
And that was roughly during the time period where y'all bought a building together.
Yes, correct.
And it made things simpler, or for whatever reason, you decided at that time that a joint entity made sense to own that building, right?
Correct.
Okay. All right, but those contracts there, they're not with the joint entity, correct?
No, they're not.
Those are all with you individually, is that right? Can you take a look at 23, 24, and 25?
Yes.
They're all with you individually?
Yes.
Okay. 23, what's the hourly rate that you were being compensated? I think that was the first appearance.
23 is the, I don't think, no, 23 is not the first appearance. 23 is the taint, it says.
What's the hourly rate on that contract?
150 an hour.
150 an hour? All right. So the 150 an hour, the way I understand you all shared profits was you get 50, Mr. Campbell get 50, Mr. Wade get 50, and then y'all pay expenses jointly as well, correct?
Correct.
All right. What about exhibit number 24?
It seems to be the same.
Same amount?
I don't know if it's the same amount.
I'm interested in the amount. Can you tell me
Oh,
the hourly
no,
rate?
the amount was 65 an hour.
$65 an hour?
Mhm.
All right. That's not a particularly high rate for an attorney in the Atlanta metro area, correct?
No, it's not.
All right. Was that a government rate that you were willing to accept at that time?
Yes, that is correct.
All right. And so the $60 you're getting for that contract, again, that's split three ways, you, Mr. Wade, and Mr. Campbell, correct?
That is correct.
So when you were being
Minus
asked,
expenses and stuff like that. but yes.
exactly. That was the income, and then expenses come from that, and then profits, whatever's at the end, correct?
Correct.
All right. So when you were being asked questions about Mr. Wade, I think the phrasing, and I object to, but I think you might recall the question, Mr. Wade brought you this contract, or Mr. Wade got you this contract. Do you remember those questions?
Yes, I do.
All right. So we're talking then about the split among the three of you of about $20 a piece, right? For that particular contract?
For this one, yes,
All right. What about 24? You got 24 there? I'm sorry, 25. You got that in front of you?
I do.
What's the hourly rate on that one?
It's 150.
150 on that one too? All right. And the same sharing went through the business, the way you handled that contract as well, right?
That's correct.
All right. Who is Austin Dabney?
He was a probation officer that passed the bar, and we hired him and another individual. The other person didn't stay long.
And did Mr. Dabney and the other legal associate that you all had working for you at that time, did they do some work on these first appearance contracts?
Yes.
And that was a pretty good position for a younger lawyer to be sent to get some courtroom experience, correct?
That is correct.
All right. 2020, you're aware that Mr. Wade had a serious illness during that time?
I'm aware.
And you and Mr. Wade, I think you described your relationship in a lot of details earlier about specific circumstances, but you were business partners in, let's say, up till the time you left in summer 2022, correct?
That is correct.
You were business partners up until that time?
Yes, I said yes, that is correct.
Okay. And while you didn't socialize together frequently, you considered yourself a friend of Mr. Wade at that time?
Yes, we were friends at the time, yes.
All right. You are no longer business partners.
That is correct.
You are no longer friends.
I mean, if he's saying that we're not friends, then
I
yeah.
want to know what you think, Mr. Bradley. Do you consider yourself a friend of Mr. Wade?
I would consider,
It goes to potential bias. Ms. Cross.
Would I consider myself a friend of Ms. Wood?
Mhm.
I would.
You were asked questions, Mr. Bradley, about the circumstances under which you left the firm. Do you recall those questions?
I do.
All right. And you left the firm. The firm remained the same as far as other employees, Mr. Wade, Mr. Campbell, as the named partners of the firm. You were the one who left, correct?
That is correct.
And you termed it as a disagreement. You recall answering questions as though you left due to a disagreement. Yes?
Yes.
And that disagreement was that there was an allegation of sexual assault by an employee made against you, correct?
That is incorrect.
There was not an allegation that you sexually assaulted one of the employees in the firm.
That is incorrect, but yes. Yes.
Yes, there was an allegation that you sexually assaulted a member of the firm, correct?
Yes, there was an allegation. Yes,
And as a result of that allegation, you left,
I did.
and you were no longer business partners with Mr. Wade.
That is correct.
The firm remained intact, and in fact, the employee involved remained with the firm, correct?
I'm not certain of that. They did leave the building, of course, and I don't know. Some of the employees did leave.
Mr. Bradley, you in fact paid that employee $20,000, correct?
That is incorrect as far as what was. No.
On or about the time that you left the firm, and on or about the time that the allegation of sexual assault was made against you, did you pay the person who had made the allegation of sexual assault any amount of money?
There was money left in an escrow that belonged to me. I don't know what that amount was.
And did that money that was left in the escrow that belonged to you, was that paid to the employee who said that you sexually assaulted her?
I never signed any, I never gave any money. I left the money in the escrow account. What happened to that money? I can't, I don't know what happened to it.
For what purpose did you leave the money in the escrow account when you left the firm?
I left the money in the escrow account.
For what purpose, sir?
There was no purpose.
You just left the money in the escrow account?
Yes.
If there's no connection to the money you left in the escrow account and the allegations of sexual assault that an employee of your firm made against you, why was it that you brought to my attention? Why did you respond the way you did about money in an escrow account when my question was, did you pay this employee any money?
I didn't hand any money. It was money from my escrow account, to my knowledge.
To your knowledge, where did the money in the escrow account go?
To the employee.
To that employee. Was there one allegation or one incident of sexual assault with this employee, Mr. Bradley, or was there more than one?
Just one incident.
There were not two.
To my knowledge, there were not two incidents. No.
I'm asking for incidents that you have been involved in. Were there two incidents where you sexually assaulted this employee?
No. I
There's
didn't
only
sexual assault anybody.
Was there another occasion where you paid any money as a result of an allegation of sexual assault against you?
No.
Did you sexually assault any clients of your firm?
No.
Never.
Never.
Who's Anna Rodriguez?
I don't even know their name.
You don't recall a client named Anna Rodriguez?
Anna Rodriguez? No, I do not.
Never met
I do not recall the name Anna Rodriguez.
Pardon me, Your Honor, I would object to this. I'm not sure what we're trying to do here. So I would object to this finding of that question.
All right, Ms. Cross.
Your Honor, this clearly goes to the bias that the witness has towards Mr. Wade. and other individuals, his motive in
Okay.
involvement. And I believe it's an appropriate avenue to pursue based on exploring his credibility.
At some point, though,
I'm not
it won't.
going to go much further.
Okay.
Judge, if this is allowed to continue in this way, it does appear a little bit harassing, then is Mr. Bradley going to be excused from his privilege because this is not.
That's what I was gonna do. Don't do that yet. Just sit on it. I think she's already done that.
Your Honor, I'm asking in all seriousness, that privilege, although.
Based on the answer right now, I think now we've opened up a whole area. What he has just responded to, he previously said was privilege. That doesn't sound like privilege to me. We'll have to address that when we go back through the run. So, Ms. Cross.
I'm finished.
Okay. Mr. Sadow.
You were accused by Mr. Wade of misconduct in the course of your representation of Mr. Wade, correct?
I was not accused by Mr. Wade, no.
Who accused you? Did Mr. Wade not, based on the questions were just asked, did Mr. Wade not bring to your attention the sexual assault allegations?
Ask that again, please.
Mr. Wade brought to your attention the sexual assault allegations that you've been asked about by the prosecutor, correct?
Correct.
And at that time that Mr. Wade brought those allegations to your attention, you were still the attorney for Mr. Wade, correct?
Correct.
And therefore, your conduct as an attorney and the attorney at that time for Mr. Wade was called into question by Mr. Wade's passing along to you allegations of misconduct, correct?
I object to that. I don't think that's factually true. I don't know that that's not, I know that that is not legally true. The attorney-client relationship is of a matter. It is not vitiated by other instances or anything outside that matter.
I'm not sure that that's accurate. He was accused by Mr. Wade, his client. Do you mind if I speak? I allowed you to speak. Mr. Wade accused this gentleman of misconduct in the performance of activity while he's an attorney working with Mr. Wade and representing Mr. Wade. Those allegations of misconduct open up the question of whether or not he can defend himself by now discussing his confidential communications with Mr. Wade in connection with the representation as well as the allegations. That's the position of the defense.
Understood. So what is the question you're putting?
My question I'm going to ask you now is, tell us what Mr. Wade told you about when he began his relationship with Ms. Willis.
All right. So where I think we are with this is that Mr. Bradley previously testified that the reason he left the firm was totally and completely covered by privilege. When asked by the state, he went into a factual scenario that, to my mind, I don't see how it relates to privilege at all. And so now I'm left wondering if Mr. Bradley has been properly interpreting privilege this entire time. And I think the only way I can cure that is by having that in-camera conversation with him.
May I suspend my redirect for you to have that conversation?
I think that makes sense. But is there anything else though that you were going to cover other than this issue?
No.
Okay. Ms. Cross, any reactions?
Only to, Your Honor, the premise of Mr. Sadow's question was that Mr. Wade accused Mr. Bradley of the sexual assault. That was not my question. I don't believe that's factual, though there was an employee who accused Mr. Bradley of sexual assault.
Okay. But regardless, though, the point is that the circumstances of his departure from the firm, from what I've now heard, had nothing whatsoever to do with his representation of a divorce. Is that fair?
My question, I believe the testimony has been that the circumstances of Mr. Bradley leaving the firm were related, I can't say how much, but certainly in a large part, based on the allegation of sexual assault that was made against him by an employer.
Sure. And his previous testimony was that that was totally covered by privilege.
Yes, he lied.
Okay. All right. Other than this issue, which I think we've covered at length, was there any other questions based on Ms. Cross's examination from other defense counsel?
No, Judge.
Okay.
No, yeah.
All right. With that understanding, can this witness be excused, Ms. Merchant?
Yes, Judge.
All right. So, Mr. Bradley, I would ask, I don't know if we may be able to do it today.
I'm sorry, because I don't think I can excuse him. Mr. Sadow had reserved the rest of his cross for after you determine the correct the privilege.
Right. What I'm about to say just logistically is, what I'm trying to do is, if we can conclude this hearing with the exception of that in-camera hearing, we end for today. And if as a result of that in-camera hearing that I learned that we need to reopen the evidence, then that's what I'll do. So to that end, I can give Mr. Bradley instructions that he's to report back if on order of the court, but otherwise, is there anything further the parties need from him today?
Not from him, but I wanted to get those certified.
I know there's other housekeeping things and things we need to do.
And based on the testimony, we do have another witness, Your Honor. It doesn't involve Mr. Bradley
Right.
requiring to be here.
Okay, so now the state does have a witness.
I do.
Okay, all right, in that instance, okay, Mr. Bradley, you can step down, sir. However, I'm giving you the order to stay in touch with your attorney, and then we're gonna have to find a time to meet again and go into a camera session. Do you understand, sir?
I do.
Okay. All right, thank you, sir. You can step down. Ms. Chopra, do you have a card for me?
I do.
Okay.
At least I hope I do.
I'm the worst lawyer on earth. I usually just tag bus stations with my
You can
name.
write down your contact information for us?
I will.
All right. Ms. Merchant, do you have any further witnesses?
No, Judge.
Okay.
Your Honor, on the issue of the Bill Selinsky, the 1006 first 611, we're not going to call him. We think the chart, the foundation of the source of the chart is sufficiently in evidence, and we can just use the chart during argument under a 611 demonstrative.
Okay. And any objection to this entry as a demonstrative, Ms. Cross?
No, Your Honor. Given the parameters we discussed earlier.
Okay. Can we go ahead and mark that an exhibit and make it part of the record in advance of arguments? Since I don't know when we're going to be able to have that scheduled. I think this would be Defense Exhibit 28. Well, let me go down the order just so we're staying organized. Ms. Merchant does not have any further witness. Excuse me. Ms. Merchant, on behalf of Mr. Roman, has no further evidence. Mr. Sadow.
Your Honor, we are in the process, as the court will allow us to obtain certain phone records, and we'd like the records kept open for the introduction of those phone records. We have them in draft. I say draft, we have them informally, we do not have certification. And they will deal with, remember I asked Mr. Wade about certain activity down in Hapeville during the time period, and it deals with that specific time period. So we're talking about February to March of 2021 to November 1st.
And is it your intention that you would want to introduce these solely as an exhibit, or do you think that this should reopen and bring us back for an entirely new evidentiary day with witnesses?
I think that we would want to, if what we believe is there, based on our preliminary research, is there, we'd like to reopen and be able to introduce the records and someone to explain what they mean. But
Sir, the state certainly has. Sorry, were you finished, Mr. Sadow?
I believe so.
All right.
State would certainly have an objection to that. This hearing has been set. We haven't seen the records. I don't know if I have any objection to what they are. But the day has been set for quite a while. We object to leaving the evidence open for any purpose.
Okay. And Mr. Sadow, how did you first go about trying to obtain these records?
I think, I know it's also the Delta records. As soon as we got a hearing date and the state's response, so what happened was when the state responded, I think it was February 9th, and admitted to the relationship but put parameters on the timing, I sent some subpoenas out in response to that, so that was February 9th. Problem is Delta, AT&T, all these folks aren't super fast about that. And so I know Delta, we're also waiting, I wanted to remind the board, waiting for those records to be submitted in camera. And AT&T actually emailed me these phone records yesterday morning on the way to court.
Okay. All right. Any further exhibits that are self-authenticating? If council are able to provide those, obviously serve those on opposing counsel, and then before sending them over to us, let us know whether they would be tendered with or without objection, just purely on authentication or hearsay issues or relevance. We can make those part of the record, and I'll reserve whether this reopens a full hearing format, but the exhibits themselves I'm willing to have come into the part of the record, but there will be a cutoff point very soon as we schedule argument. All right. Any other evidence, Mr. Sadow, then?
No, Your Honor.
So that would be cell records. Mr. Stockton? Any evidence? All right. Mr. Durham, if you're still with us?
No, Your Honor.
All right. Mr. McDougald?
Certified copies I mentioned to Your Honor yesterday, Your Honor.
Okay. And why don't you lay those out for the record?
They are marked but not yet numbered. I believe our next exhibit would be 29.
28 I just said was Mr. Gillen's, just so I'm keeping it straight.
And so I previously provided these to the prosecution. 29 would be a certified copy of County Code Section 2-68.
Okay.
30 is a certified copy of County Code Section 2-69. 31 is a certified copy of County Code Section 2-79. 32 is certified copy of County Code Section 10-114. 33 is a certified copy of County Code Section 10-115. 34 is a certified copy of County Code Section 102-464. 35 is a certified copy of County Code Section 102-465. 36 is a certified copy of County Code Section 102-466. And 37 is a certified copy of a emergency motion by non-party deponent for protective order filed on behalf of D.A. Willis in the Wade divorce case.
Okay. Ms. Cross, objection to defense exhibits 32 through 37.
I object to their relevance, and I will take opposing counsel's representation that the pleading is complete and accurate as it was filed, and object to the relevance of that as well, but not the authentication.
Okay. All right. We'll note the objection for the record, and we'll admit them for whatever way they do. So defense exhibits 32 through 37 are admitted. If you can hand those to Madam Court for. Any further evidence, Mr. McDougall?
No.
Okay. Mr. Rice?
No, Your Honor.
Mr. Gill? The demonstrative 38 or 28? Okay. And do you have a physical copy for us already? Great. All right. Do we still have Mr. Kuchera with us on Zoom, or anyone else on behalf of Mr. Floyd? He's not on any longer? All right. I'm being informed that he dropped off Zoom, and so I'll make a finding that he voluntarily has absented himself from this hearing. Mr. Cromwell?
No evidence, John.
Okay. Ms. Cross, back to you.
If the defense presentation of evidence is done, I'd ask that all of the witnesses who had been subpoenaed but not called now be released.
I think that's fair. Ms. Merchant, any reason to hold on any of those witnesses?
No, Judge.
Okay.
And the state has 2 short witnesses, and that's it.
Okay, you may call your next witness, Ms. Cross.
Next witness for the state is Austin Dabney.
These witnesses are going to be
Impeach the testimony, Mr. Bradley?
On the collateral matter, we'll wait.
Okay.
Yes, my name is Austin Dabney. That's AUSTIN DABNEY.
Good afternoon, Mr. Dabney.
Good afternoon.
I want to direct your attention, well, first of all, how are you employed?
I am employed right now at my own firm.
You're a lawyer and you've got your own law firm?
That's correct.
All right. I want to direct your attention to 2021, 2022. What was your employment at that time?
Yes, I was employed with Wade Bradley Campbell firm.
And that's Nathan Wade, Terrence Bradley, and Chris Campbell?
That's correct.
All right. And what did you do in that firm?
I was an associate attorney.
All right. And don't need a whole lot of detail, but generally speaking, who in the firm did you work for? What kind of matters did you handle?
Well, I believe I worked for all of them equally. They would all give me tasks to do, which court dates to go to, what cases to work on.
I want to direct now your attention, Mr. Dabney, to a particular instance. Did you have occasion at any time to go to a club with Mr. Bradley?
Could you repeat the question?
Yeah. Did you have any occasion to go to a club, a nightclub or a bar situation with Mr. Bradley?
Yes, I have.
More than one time?
More than one time, yes.
The time that I'm going to direct your attention to, we spoke about a little earlier today. Do you recall any instance, Mr. Dabney, where Mr. Bradley, where you witnessed Mr. Bradley sexually assaulting him?
Your Honor, I object to this. Specific instance of
Sure.
impeachment is improper.
All right, how is this not extrinsic evidence in a collateral matter, Ms. Cross?
Maybe ask a better question. Yeah, my question will be if this witnessed Mr. Bradley sexually assaulting another employee of the firm.
Same subject matter. How is that not issue on a collateral matter for impeachment?
I think it's not a collateral matter. The witness denied it. I think it is highly relevant. I think that it goes to the witness's credibility and his denial here this afternoon that he committed the assault. There's a witness I will proffer to the court who has firsthand knowledge and witnessed the event. And so I think that's highly relevant to both Mr. Bradley's credibility and to the proceedings that we had for the last 2 days.
Still object, Your Honor.
I understand, Mr.
In the attempt to impeach Mr. Bradley, they have to live with whatever answer he gave. They can't have a sub-trial with the intrinsic evidence of misconduct here. So we would object.
608A. Right? 24-608.
Ms. Cross, under 608, I don't see how this isn't well beyond the core facts of the issue. I think you confronted with him. I think he answered in this. He saw fit an argument can be made as a result. But to go down a whole mini trial on whether he did or did not do this and circumstances of his leaving the firm, I don't see how that gets past 608.
I understand the ruling, Your Honor. Disagree, and just for my objection, I put a proffer on the record, not a detailed one, but that
I think you already have.
I'd like to, with the court's permission, I'd like to make it clear that the sexual assault I'm referring to was the same employee that I asked Mr. Bradley about. I just wanted that to be clear in the record.
Okay, all right, understood. Is there anything else that is relevant to this witness?
Given the court's ruling, no.
All right. Questions from defense counsel?
Good afternoon, sir.
Good afternoon.
When did you start working at the law firm?
I believe I started working, to my recollection, March 2021.
Okay. And at that time, do I understand that there was what I would call a three-way partnership or sharing arrangement at the law firm?
I'm not aware of any sharing arrangements that they had, but there was the Wade, Bradley, and Campbell law firm.
Okay. And did you work in the law firm office on a daily basis?
I did.
And during the time period, you were there for the remainder of 2001? That is, you worked from March of 2001 at least to the end of 2001, correct?
I didn't even have a bar license in 2001.
I'm sorry, 2021. It's a little late. From March of 2021 to the end of 2021, correct?
That's correct.
Okay. During the time period that you were working at the law firm, did you see Fani Willis?
During my time, could you repeat
In that time period between March of 2021 and November 1st of 2021, did you see Miss Willis?
I may have recalled one instance where I saw her in passing.
And when you saw her, was she at the law firm?
That would be correct.
And do you know who she went to visit?
I do not know.
You didn't see her go to Mr. Wade's office?
I do not recall.
Did you ever talk to Mr. Wade about Fani Willis?
Could you repeat your question?
Did you ever talk to Mr. Wade about Fani Willis during the time period of March of 2021 to November 1st of 2021?
No.
Did you know they were dating?
No, I did not.
Did you see anything did you ever socialize with Mr. Wade?
As far as being an employee, yes.
Well, I don't know what that means exactly, but did you ever go out to eat with Mr. Wade?
On occasion, he would take the office out to lunch.
Beyond that, did you ever go to a nightclub or drinking or any of that with him?
No, I did not.
Okay, so whatever relationship Mr. Wade had with Miss Willis during this time period, you don't have personal knowledge, correct?
I do not have any personal knowledge.
Thank you very much for being here.
Thank you.
Any other questions from the defense counsel? Mr. Stockton?
When you started in March of 21, was that just you gave them a resume and started working there?
I don't understand your question.
When you started working there, is it a situation where your first day on the job is the first day you may have met him or shortly before you met him?
Again, I don't understand what you're asking.
Let me back up. Did you know Mr. Wade or any of his partners prior to March of 21?
Yes, I did.
How did you know them?
In a professional capacity. I used to be a community supervision officer with the Georgia Department of Community Supervision.
And where would that have been out of Fulton County?
Cobb County.
How long did you know Mr. Wade prior to that?
I didn't see Mr. Wade in my professional capacity. I thought you were asking about all partners, but if you're only asking about Mr. Wade, if you could please clarify.
Okay, so you went to work for Mr. Wade in March of 21, correct?
I went to work for the Wade Bradley Campbell firm.
Okay. Prior to that, how long did you know Mr. Wade?
I did not know Mr. Wade prior to that.
At all?
At all.
No further questions?
Any other counsel?
All right.
Seeing and hearing none? Any redirect, Ms. Cross?
No, Your Honor, subject to the court's ruling.
All right, can this witness be excused?
May.
All right, thank you, sir.
Thank you, Your Honor.
Next witness, Ms. Cross.
I believe I know the court's ruling, so let me proffer that the next witness the state would call would be Anna Rodriguez. Question, Mr. Bradley, about the sexual assault of Ms. Rodriguez, a client of the firm. He denied knowing her or recognizing her name. I believe Ms. Rodriguez's testimony would be impeaching of Mr. Bradley. I believe it's appropriate, but want to present that before I call.
All right, thank you, Ms. Cross. And so, based on that proffer and the subject matter proffered, I still believe that would fall under 608B as extrinsic evidence of a collateral matter. And so I don't think it's allowed under our rules of evidence.
Understanding that, I just make a proffer on the record that Ms. Rodriguez would testify that Mr. Bradley sexually assaulted her. She was a client at the time. And that would be impeaching of his testimony that he denies.
All right, understood. Any further evidence or witnesses, Ms. Cross?
No, sir.
Okay. All right, then at this time, for now, I'll consider the evidence closed, subject to any certified submissions by counsel and subject to the results of the in-camera hearing. We will coordinate with all counsel to find a date to come back for summation. And to that end, again, using Ms. Merchant as kind of running lead on this, I'd like you to consult on whether that's going to be a collective response on behalf of the defendants. If not, then we're going to have to get into the time allotment. And if it's more than a handful of counsel, it probably maybe be 10 to 15 minutes per side. And so, Mr. Sale.
When did you say this might happen?
We'll follow up by email so we can coordinate with everyone's schedules. I want to make sure we have our same court reporter as well, so that the record is all in one place. And I know we have a lot of schedules to coordinate, but looking at either late next week, as in next Friday, or the following week.
And would we at least have the opportunity to get a transcript before we do that?
I think that's probably highly unlikely, but we'll see. It's just that would require a rush, and I know again we're in a shortage of court reporters, but I think there are other means you can refer to the evidence with confidence as to what was said.
All right.
Ms. Merchant.
Merchant's on.
Okay.
You said next
Like I said, we will. We're gonna follow up with scheduling.
Thank you.
Now, Your Honor,
Mr. Gillum.
the argument would be on this hearing, and
And
also on the forensic misconduct.
any other claims brought in any of the filings regarding forensic misconduct, this whole line of question. All right. Any other questions from defense counsel? Anything from the state?
Your Honor, we would just ask that we be allowed to submit a brief as it relates to the rulings that you just made. It relates to the objections by defense counsel under 607 and 6021, which is the impeachment by contradiction, which in the state's understanding would allow the use of extrinsic evidence to impeach the specific testimony here of Mr. Bradley. So we're just asking for leave to provide a brief and ask the court to further consider your ruling.
Well, if you still got your witnesses here and you think you've got a better legal argument, I'm willing to hear it. You said 607 and 608.
607 and 621.
Okay, I see 621, I see 608. And
in both of those instances, they allow testimony that related to the testimony of another witness here, Mr. Bradley, that we can prove this is patently false, as he testified that he didn't commit a sexual assault and that he didn't pay off witnesses and things of that nature.
okay, and how do you get around 608B's prohibition on extrinsic evidence of collateral matters?
Both 607 and 621 allow the use of extrinsic evidence to specifically impeach facts known to be false.
But if that held true, respectfully, that would mean that any time any witness denied something, you'd be able to, of a matter testified to, you'd be able to impeach with extrinsic evidence, and that's respectfully, that's not.
Well, here's what I'm fine with, Mr. Abadi. If you want to submit that brief on purely legal argument, you can, but I don't want to have this as a vehicle to essentially put forth an extended and long-winded proffer of what you expected the evidence to be. So if you think I've made a legal error on that point, feel free to brief it, and we can reopen the hearing if that's legally invalid. Okay? All right. Mr. Chopra, is your client still here?
I believe so, Your Honor, but I'm sorry.
That's fine. If he is still here, let's relocate to the jury room. Okay. We will be adjourned for today. Thank you all.